The House will come to order. This morning, we will have a presentation of colors from the Civil Air Patrol.
Please join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Members, our thanks to Cadet Captain Justin Champeau for the Pledge of Allegiance, and to Color Guard Cadet Chief Master Sergeant Victoria Heim, Cadet Captain Caitlin Miller, Cadet Captain Devon Sherrock, and Cadet Sergeant Eva Waters for presenting the colors this morning. Mr. Schiebel, please call the roll.
Representatives Armagast, Bacon, Barone, Byrd, Basenecker, Bottoms, Bradfield, Bradley, Brooks, Brown, Caldwell, Camacho, Carter, Clifford, DeGraff, Duran, English, Espinoza, Ferre, Froelich, Garcia, Garcia Sander, Gilchrist, Gonzalez, Hamrick, Hartsook, Jackson, Johnson, Joseph, Kelty, Leader, Lindsay, Linstead, Luck, Lukens, Mabry, Representative Mabry is excused. Marshall, Representative Marshall is excused. Martinez, Morrow, McCormick, Pascal, Phillips, Puglisi, Minority Leader Puglisi,
Excused.
Richardson, Ricks, Representative Ricks,
Excused.
Rutinell, Ryden, Sirota, Smith, Soper, Representative Soper,
Excused.
Stewart K, Stewart R, Story, Sukla, Taggart, Titone, Representative Titone, Valdez A, Velasco, Weinberg, Representative Wilford is excused. Winter, Woodrow, Woog, Rep. Kai is excused, and Madam Speaker.
Here. With 59 present, 6 excused, we do have a quorum. Representative Johnson.
Thank you, Madam Speaker. I wanted to share a fun little situation I had with one of the kids that I help watch and teach after an after-school program. So while she was sitting in the corner, she had 2 cans of pop. And she's looking at them, she's examining them, slowly stacking them on one top of each other, and I finally ask her, why do you keep assembling and reassembling what they're doing? And she looks at me and says, well, what do you see? And I said, well, I see 2 cans. And she said, exactly, I made a bird. Toucan. So let us please remember the innocence of a child and the creative way that they look at the world. Madam Speaker, I move that the Journal of Tuesday, April 1st, 2025 be approved as corrected by the Chief Clerk.
Representative Johnson, that was outstanding. You have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. All those opposed, no. The ayes have it. The motion is adopted. Members, we do have business to attend to. Please take your seats. Mr. Schiebel. Oh, sorry, Madam Majority Leader.
Thank you, Madam Speaker. I move to proceed out of order for consideration of third reading of bills, final passage.
Seeing no objection, we will proceed out of order for third reading of bills, final passage. Mr. Schiebel, please read the title to House Bill 1001.
House Bill 1001 by Representatives Duran and Froelich, also Senators Danielson and Kolker, concerning the enforcement of wage and hour laws and in connection therewith making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1001 on third reading and final passage.
Representative Luck.
Good morning, colleagues. Thank you, Madam Speaker. Yesterday, I asked a few questions of the bill sponsors that were not answered. Not quite sure why I'm still having some questions about this bill. And as a present to a colleague, I asked this bill to be read at length.
The bill has been asked to be read at length.
House Committees, Senate Committees, Business Affairs and Labor Finance Appropriations. A bill for an act. 101 concerning the enforcement of wage and hour laws, and, in 102 connection therewith, making an appropriation. Bill summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.gov. Section 1 of the bill amends the definition of employer for purposes of wage and hour laws to include an individual who owns or controls at least 25% of the ownership interest in an employer. Section 2 prohibits an employer from making a payroll deduction below a worker's applicable minimum wage. Section 3 allows the Director of the Division of Labor Standards and House amended second reading April 1, 2025. House sponsorship Duran and Froelich, Bacon, Bosnecker, Clifford, English, Garcia, Hamrick, Leader, Mabry, Martinez, Morrow, Rudnall, Sirota, Titten, Velasco, Wilford, Zokai. Senate sponsorship Danielson and Coker, Bridges, Cutter, Gonzalez J., Hinrichsen, Kipp, Marchman, Michelson Jennett, Sullivan, Weissman, Winter F. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing law. Dashes through the words or numbers indicate deletions from existing law. Statistics, division, to waive the penalty for an employer's failure to pay claimed wages or compensation within 14 days after a written demand if certain specified conditions are met. Section 4 repeals language allowing a court to award an employer reasonable costs and attorney fees in a civil action for unpaid wages or compensation in certain circumstances. In such an action, the court may pursue all equitable relief to deter future violations and prevent unjust enrichment. Current law limits the ability of the director of the division to adjudicate claims for non-payment of wages or compensation to $7,500 or less. Section 5 increases this threshold over the years by increasing the amount to $13,000 for claims filed from July 1, 2026, through December 31, 2027, and in an amount specified by the director of the division to adjust for inflation beginning January 1, 2028. Section 5 also requires the division, in adjudicating wage claims, to determine whether a violation is willful. For each violation, the director shall publish on the division's website the names of all employers found to be in violation and whether the violation was willful, and if the violation is not remedied within 60 days after the division's finding that there was a violation, the division must notify all government bodies with the authority to deny, withdraw, or otherwise limit or impose remedial conditions on the employer's license, permit, registration, or other credential. Additionally, the division may report an employer found to have violated a law related to wages and hours to any government body with authority to deny, withdraw, or otherwise limit or impose remedial conditions on a license, permit, registration, or other credential that the violating employer has or may seek. Section 5 also repeals language requiring the division to issue a determination on a wage complaint within 90 days. Section 6 requires an employer found to have misclassified an employee as a non-employee to pay a fine in the following amounts, in addition to any other relief ordered. For a willful violation, $5,000. For a violation not remedied within 60 days after the division's finding, $10,000. For a second or subsequent willful violation within 5 years, $25,000, or for a second or subsequent willful violation not remedied within 60 days after the division's finding, $50,000. The director of the division must adjust these fine amounts for inflation by January 1, 2028, and every other year thereafter. Section 6 also decreases the amount of time the division must wait. -2, 1001. Before paying an employee out of the Wage Theft Enforcement Fund from 6 months to 120 days. Current law prohibits an employer from discriminating or retaliating against an employee for taking protection under wage and hour laws or the law related to the employment of minors. Section 7 expands this provision to specify additional protected behavior and expands the prohibition to include other persons in addition to employers. Section 7 also requires a fact finder to consider the time between an individual's exercise of a protected activity and an employer's adverse action when determining whether an employer has retaliated against the employee or worker. Specifies that any effort to use an individual's immigration status to negatively impact the wage and hour law rights, responsibilities, or proceedings of any employee or worker is an unlawful act of intimidation, threatening, coercion, discrimination, and retaliation, and allows the division to order reasonable attorney fees and costs after investigating a discrimination or retaliation claim. 1. Be it enacted by the General Assembly of the State of Colorado. 2. Section 1. In Colorado Revised Statutes, 8-4-101, amend, 6. 3 as follows. 48-4-101. Definitions. As used in this Article 4, unless the context 5 otherwise requires. 6. Employer has the same meaning as set forth in the federal 7. Fair Labor Standards Act of 1938, 29 U.S.C. Sector 203, D, and includes 8. A foreign labor contractor, and a migratory field labor contractor or crew. 9. Leader, and each individual who owns or controls at least 10-25% of the ownership interests in an employer. 11. Except that the provisions of this Article 4 does not apply to a 12. Minority owner of an employer that demonstrates full 13. Delegation of its authority to control day-to-day operations of 14. The employer, the state or its agencies or entities, counties, cities and 3. 1001. 1. Counties, municipal corporations, quasi-municipal corporations, school 2 districts, and irrigation, reservoir, or drainage conservation companies or 3 districts organized and existing under the laws of Colorado. 4. Section 2. In Colorado Revised Statutes, 8-4-105, amend, 2-5 as follows, 68-4-105. Payroll deductions permitted, notice required. 7.2. Nothing in this section authorizes a deduction below the applicable 8 minimum wage. Applicable under the Fair Labor Standards Act of 1938, 929 U.S.C. Sector 201 E. Seek. 10. Section 3. In Colorado Revised Statutes, 8-4-109, amend 11.3b, introductory portion, and add 3.5, as follows, 12.8-4-109. Termination of employment, payments required, 13. Civil penalties, payments to surviving spouse or heir. 3b, on or 14 after January 1, 2023 except as provided in subsection 3.5 of this 15 section, if an employer fails or refuses to pay, in the manner specified. 16. In subsection 3d of this section, all earned, vested, and determinable. 17. Wages or compensation within 14 days after the written demand. 18. Is sent or within 14 days after a civil action or administrative claim. 19. For the wages or compensation is sent to or served on the employer, the 20 employer is liable to the employee or group of similarly situated 21 employees for the amount of the earned, vested, determinable, and unpaid 22 wages or compensation plus an automatic penalty of 23, 3.5. The director may waive the penalty specified in 24. Subsection 3b of this section for an employer's failure to pay 25 claimed wages or compensation within 14 days after a 26 written demand if the employer pays all claimed wages or 27 compensation within 14 days after an administrative. 4. 1001. 1 claim for the same wages or compensation is sent to or served on to the employer. The director shall not waive the penalty if the 3 alleged violation is a second or subsequent failure or refusal to pay an employee's wages or compensation within 5 years. 5. Section 4. In Colorado Revised Statutes, 8-4-110, amend 6.1a, introductory portion, 1a, 2, and 2, as follows, 7.8-4-110. Disputes, fees. 1a. The court may award the aid employer reasonable costs and attorney fees incurred in a civil action 9 brought under this Article 4 if, within 14 days after a written 10 demand letter is sent to or a civil action is served on the employer for 11 unpaid wages or compensation. 12.2. The employees receiving such tender ultimately fail to recover 13 a total sum that is greater than the amount the employer tendered. The 14 court ultimately finds that the employees receiving such tender 15 pursued an action lacking substantial justification. 16.2. Any in addition to other relief available to employees. 17. Under this Title 8, a person claiming to be aggrieved by a violation of 18 any provisions of this article or regulations prescribed pursuant to this 19 article, this Article 4, or any other law or rule related to wages 20 or hours may file suit in any court having jurisdiction over the parties. 21. To pursue all available equitable relief, including equitable 22 relief to deter future violations and prevent unjust enrichment. 23. Without regard to exhaustion of any administrative remedies. 24. Section 5. In Colorado Revised Statutes, 8-4-111, amend 25, 1a, 2, 2a, I, introductory portion, and 8, repeal, 2a, 3, and 26 add 1a.5, and 9, as follows, 27 8-4-111. Enforcement, duty of director, duties of district or. 5, 1001. 1. City attorneys, local government authority to enact and enforce laws. 2. Rules. 1a. 2. The director may establish an administrative 3 procedure to receive complaints and adjudicate claims for non-payment of 4 wages or compensation of 5. $7,500 or less for claims filed 6 through June 30, 2026, 7b. $13,000 or less for claims filed 8 from July 1, 2026, through December 31, 2027, and 9c. An amount that the director specifies in rule by January 10, 2028, and by rule for every other year thereafter. 11. Such amount must be equal to the amount in the previous 12 calendar year increased by $1,000 or a higher 13 amount if such higher amount is necessary to adjust for 14 inflation. Inflation is measured by the annual percentage 15 change in the United States Department of Labor's Bureau of 16 Labor Statistics Consumer Price Index, or a successor index, for 17. Denver Aurora Lakewood for all items paid for by Urban. 18. Consumers. 19. A.5. In carrying out the duties specified in subsection 21, a, I, of this section, the Director, 21I, shall publish on the Division's website, for any 22 violation that is a matter of public record pursuant to Section 23(8-1-115), 1b, the citation, determination, or written opinion. 24 whether the violation was willful, and the names of all 25 employers in violation. 26, 2, shall report an employer with a willful violation. 27 unremedied within 60 days after the Division's finding to any. 6, 1001. One government body with authority to deny, withdraw, or to otherwise limit or impose remedial conditions on the employer's 3 license, permit, registration, or other credential. The Division may forth post a decision against an employer by a government body. 5 on the Division's website. 6, 3, may report an employer found to have violated a law. 7 related to wages and hours to a government body with 8 authority to deny, withdraw, or otherwise limit or impose 9 remedial conditions on the employer's license, permit, 10 registration, or other credential. The Division may post a 11 decision against an employer by a government body on the 12 Division's website. 13, 2, I. The Division shall investigate a wage complaint. 14 if one or more employees file a wage complaint with the Division. 15 claiming unpaid wages or compensation, exclusive of penalties, and 16 fines, of $7,500 or less per employee. 17 exclusive of penalties and fines, the Division shall investigate the wage. 18 complaint for claims filed through June 30, 2026, 13 $19,000 or less for claims filed from July 1, 2026, 20 through December 31, 2027, and an amount that the Director 21 specifies in rule by January 1, 2028, and by rule for every other 22 year thereafter. Such amount must be equal to the amount in 23 the previous calendar year increased by $1,000 24 or a higher amount if such higher amount is necessary to adjust 25 for inflation. Inflation is measured by the annual percentage 26 change in the United States Department of Labor's Bureau of 27 Labor Statistics Consumer Price Index, or a successor index, for 7, 1001. 1 Denver Aurora Lakewood for all items paid for by Urban 2 consumers. The Division may investigate any a wage complaint made 3 on behalf of a group of similarly situated employees. If the Division 4 declines to investigate a group complaint, similarly situated employees may 5th consent in writing to participate as parties to that complaint, and the 6th Division may pursue a direct investigation informed by and concurrent 7 with that complaint. The Division shall initiate the Administrative 8 procedure by sending a notice of complaint to the employer by mail or 9 electronic means in accordance with rules, as the Director may promulgate 10 when the complaint states a claim for relief. The notice of the complaint 11 must include. 12, 3, the Division shall issue a determination within 90 days. 13 after the notice of complaint is sent unless the Division extends the time 14 period by providing advance written notice to the employee and employer. 15 stating good cause for the extension of time. 16, 8, nothing in this article shall be construed to limit Article 417 limits. 18, a, the authority of the District Attorney of any county or city and 19 county, or the City Attorney of any city. A person delegated authority. 20 by a county or city and county to prosecute criminal offenses. 21 or enforce laws or ordinances related to the payments of 22 wages. 2, 23, I, prosecute actions for such violations of this article as Article 24 that may come to his or her the District Attorney's or the 25 delegated persons' knowledge, or to 26, 2, enforce the provisions of this Article 427 independently and without specific direction of the Director, or to limit. 8, 1001. 1b, the right of any wage claimant to sue directly or through and to assignee for any wages or penalty due him or her under the provisions of 3 this article or other relief available pursuant to this Article 4. 4, 9, a city, county, or city and county may enact, and 5, enforce laws related to the payment of wages for work 6 performed within its jurisdiction if the laws do not diminish the 7 protections or benefits to employees provided in this Article 4. 8 Section 6. In Colorado Revised Statutes, 8-4-113, amend 9, 5, a, and add 1, a, I.5, as follows, 10 8-4-113. Fines pursuant to enforcement, wage theft 11 enforcement fund, created, administrative lien and levy of employer 12 assets, wage claim payments from the fund, definition, rules. 13, 1, a, I.5, an employer found to have misclassified an employee 14 as a non-employee in a way that may affect a wage and hour 15 payment or reporting obligation under a state, federal, or local. 16 law, rule, or regulation shall pay a fine in the following. 17 amounts, increased by the Director by rule by January 1, 2028, 18, and by rule by January 1 every other year based on the prior 19 2 years increase, if any, in the United States Department of 20 Labor's Bureau of Labor Statistics Consumer Price Index, or a 21 successor index. For Denver Aurora Lakewood for urban wage 22 earners and clerical workers, per employee, in addition to any 23 other relief ordered. 24, a, for a willful violation, $5,000, 25, b, for a violation not remedied within 60 days after 26 the Division's finding, $10,000, 27, c, for a second or subsequent willful violation within 9, 1001. 1 5 years, $25,000, or 2, d, for a second or subsequent willful violation not 3 remedied within 60 days after the Division's finding, $54,000. 5, a, on and after April 1, 2024, if an employer fails to pay in 6 employee an amount of wages, compensation, or other monetary relief 7 owed the employee, as determined by the Division pursuant to this Article 8-4 or Article 6 or 12 of this Title 8 or as decided by a hearing officer 9 pursuant to Section 8-4-111.5, within 6 months 120 10 days after the Division's determination, the hearing officer's decision, or 11 the expiration of any an order from the Division. the hearing officer, or 12 a court staying or postponing the employer's payment obligation, 13 whichever is later, the division may disperse the amount of wages, 14 compensation, or other monetary relief determined to be owed the 15 employee, subject to available resources in the fund and the divisions. 16 prioritization, from the fund to the employee. 17 Section 7. In Colorado Revised Statutes, amend 8-4-120 as 18 follows, 19-8-4-120. Discrimination and retaliation prohibited, employee 20 protections, criminal penalties, civil remedies. 1. An employer, or 21 any other person that is regularly engaged in business, or 22 commercial activity that has contracted with an employer, or 23 worker, directly or indirectly, for labor from which such 24 person is the beneficiary, shall not intimidate, threaten, restrain, 25 coerce, blacklist, discharge, or in any manner discriminate or retaliate 26 against any an employee or worker who has, 27, a, filed any a complaint or instituted or caused to be instituted. 10-1001. 1. Any a proceeding under this Article 4 or any other law or rule related to 2 wages, hours, or employment of minors, or 3. b. Testified or provided other evidence, or may testify or provide for other evidence, in any a proceeding on behalf of the employee or another 5 person regarding afforded protections under this Article 4 or under any 6 other law or rule related to wages, or hours, or the employment of 7 minors, or 8. c. Raised concerns in good faith about compliance with 9 or otherwise provided information as to legal rights, and 10 remedies available under this Article 4 or any other law or rule. 11 related to wages or hours to any person. 12. 2. An employer who a person that violates this Section 13 commits a Class 2 misdemeanor. 14. 3. An employee or worker who alleges a violation of 15 subsection 1 of this section may file a civil action in a court of 16 competent jurisdiction against the employer alleged to have violated this 17 section to seek legal and equitable relief as appropriate to remedy the 18 violation, including 19. Back pay, 22, reinstatement of employment, or, if reinstatement is not 21 feasible, front pay, 22, 3, the payment of wages unlawfully withheld, 23, 4, interest on unpaid wages at a rate of 12% per 24 annum from the date the wages were first due, 25, v, the payment of a penalty of $50 per day for each 26 employee whose rights under this section were violated and for each day 27 that the violation occurred or continued. 11, 1001. 6. Liquidated damages in an amount equal to the greater of 2 times the amount of the unpaid wages or other lost pay, or 3 compensation or $2,000, and 7. Injunctive relief, and 8. Compensatory damages for other economic or 6. Non-economic loss or injury shown by competent evidence. 7b. If the employee and aggrieved person prevails in a civil 8 action brought pursuant to this subsection, 3. The court shall award the 9 employee person reasonable attorney fees and costs. 10c. In determining whether there has been retaliation. 11. As prohibited in subsection 1 of this section, a fact finder shall 12 consider the time between an individual's exercise of a protected 13 activity and an employer's adverse action. A period of 90 or 14 fewer days between the exercise of a protected activity and the 15 adverse action may, without more, be sufficient to find 16 retaliatory intent. Adverse action occurring more than 17 days after the exercise of a protected activity may also 18 constitute retaliation. 19. 2. Any effort to use an individual's immigration status. 22. In any manner discriminate or retaliate against an employee. 21. Or worker who has engaged in activity described in subsection 22(1) of this section is a violation of this section. 23. 4. The division may investigate and enforce discrimination. Or 24. Retaliation prohibited by this Article 4 or Article 6 of this Title 8 and, after 25 investigation, may order the relief specified in subsection 3a of this 26 section and reasonable attorney fees and costs. 27. Section 8. Appropriation. For the 2025 to 26 state fiscal year. 12, 1001. $208,979 is appropriated to the Department of Labor and Employment for use by the Division of Labor Standards and Statistics. This appropriation is 3 from the general fund and is based on an assumption that the division will require an additional 1.8 FTE. To implement this act, the division may use this appropriation for program costs related to labor standards. 6. Section 9. Act subject to petition, effective date, 7. Applicability. 1. This act takes effect at 12:01 a.m. on the day following 8 the expiration of the 90-day period after final adjournment of the 9 General Assembly, except that, if a referendum petition is filed pursuant 10 to Section 1(3) of Article V of the state constitution against this act or an 11-item, section, or part of this act within such period, then the act, item, 12 section, or part will not take effect unless approved by the people at the 13 general election to be held in November 2026 and, in such case, will take 14 effect on the date of the official declaration of the vote thereon by the 15 governor. 16.2. This act applies to conduct occurring on or after the applicable 17 effective date of this act. 13, 1001.
Yes.
Members, The bill has concluded. We are speaking to the bill. Representative Richardson?
Thank you, Madam Speaker. I did rise yesterday to oppose the bill. I still do oppose the bill, but yesterday, if you hadn't noticed, the Bureau of Labor Statistics came out with some pretty dismal numbers for Colorado. Colorado employers were estimated to have added a net total of 500 jobs in the last 12 months. Rounding that off, that's a 0% increase over the last 12 months. Nationwide, we had a 1.2% increase. So when I and my colleagues stand down here and say that we're constructing a statutory and regulatory environment that is harmful to business, we're not just hammering talking points. We're hurting businesses with bills like this. We're making businesses less likely to be established in this state. We're making businesses less likely to expand in this state. These are just uncomfortable truths. We are the 6th most regulated state in the nation, and we've added 0% jobs in the last 12 years. Those two facts are related. We need to stop. We're setting up the conditions for an economic collapse in this state. We're setting up the conditions that are going to cause great harm to our citizens. So I would urge us to just stop and vote no on this bill. Thank you.
Representative DeGraff.
Thank you, Madam Speaker. Just going through these people from yesterday, the businesses, the organizations, and again, there's a lot of opposition from the business community. We're 200,000 regulations. We're 200,000 rules and regulations, many of them redundant and repetitious and duplicative. So, but instead of liberating the economy, instead of freeing the economy, and nobody, you know, a worker is worth his wages. You don't muzzle an ox while they're treading out the grain. There's, you know, the wages should be paid, but I just don't feel like this is, like, what is the reasoning behind, we're trying to deal with the symptom of a choked economy. We're trying to deal with the symptoms of a boot on the face economy, but we're not dealing with the cause. And the cause, I think, is largely the 200,000 regulations, making us the 6th most regulated state in the Union of States. And it becomes easier for businesses to go elsewhere because they feel like Colorado is waging war on the business community. And I can't dispute that. I mean, there's just regulation after regulation after regulation, and so many regulations like this, I just feel they're trying to deal with a symptom instead of the cause. And the cause is the hundreds of thousands of regulations that are trying to manipulate the economy into something. I don't even know what it's trying to manipulate the economy into some ultimate fairness thing. And the economy does so much better. The economy, what made us a thriving nation was our founding values. And those founding values, the founding values of our republic, are not Republican values. They're just the founding values of our republic. They precede the parties. So it's not that they're Republican values that I'm espousing. I am espousing the values of the republic. The values of the republic are lend towards the free market. That all men are created equal, endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Now, when you get into, say, the Communist Manifesto, the free market is considered the worst of all freedoms.
Back to the bill. I want to give you some latitude, but this needs to relate specifically to the policy before us. House Bill 1001.
Thank you, Madam Speaker. And I thought it did. I thought it did, because what we're talking about is more regulations. What we're talking about is unfreeing the economy. And there is an idea that the economy would be, you can read Bastiat, the law, the economy, the social engineering, the continual meddling, and instead of this body stepping back and saying, all right, let's free the economy, it just continually takes out and tries to shackle it into something. You know, the saying from the Scopes monkey trial was that in the beginning God created mankind and mankind returned the favor. And so we're trying to always take this and mold it into something that you want it to be instead of letting the economy breathe free. And when the economy breathes free, then we have a multitude of jobs. When we move down the scale from number 6 and move back down and become the state, you know, probably 2 decades ago, become that state where, you know, where you could move and have some independence, and you could you know, be part of that Western individualism. When we move down that, what we do is we create this expansive economy. And when you create an expansive economy, you create a lot of jobs. And when you have a lot of jobs, employers have to treat their employees well, because instead of being a liability, they're a commodity, and they have to fight to retain them. And so instead of creating an economy where where employees are sought after, these type of bills, well intended, and certainly I'm not advocating for, you know, somebody to not pay their wages, but it doesn't deal with the root of the problem. And so we need to get to the root of the problem. And we have businesses that are telling us, and they're saying, you know what, this is not the root of the problem. And none of these business organizations none of those business organizations are saying, yeah, we need to be able to stiff the employees and not pay them. They all want to pay their employees. They know that, because those employees employ the next level of business. So when we have this idea of stakeholdering, which is still a stupid word, but when we do that, was that my inner monologue? You actually have to listen to those people. You actually have to take into account what they have to say. We can't just discount them and say, well, that's like with legislation last night. Well, we don't have to listen to those people because they're a hate group. What makes them a hate group? Well, we hate what they have to say.
Representative DeGraff. No more warnings, please. Speak to the bill.
Thank you, Madam Chair. But Speaker, we have, if we're going to stakeholder with these groups, we have to actually listen to them. And we have to say, what is the actual problem? Here's a problem that we have. We want to make sure that these people are paid. But you don't want to do this bill. How do we make this happen? How do we do this that's in line with the business community that it's not? Because when I see the business community is not aligned with this, I see that this is just more regulations that we're going to have to dig ourselves out of, that the business community is going to say, I can't do it. I can't breathe with this boot on my face. We need to let the economy breathe. We need to liberate it. We need to free it. And we need to stop dealing with symptoms, and we need to deal with the cause, and we can do that easily because it's here in this room.
Representative Taggart.
Thank you, Madam Speaker. It's an honor to serve with you.
It is an honor to serve with you.
And I certainly appreciate the fact that yourself and leadership came up with Denim Day. My suits could use a rest. So I very much appreciate being in jeans today.
All for a good cause.
All for a very good cause. I want to bring to your attention, and I appreciate the fact I want to make sure I'm on the right version, the engrossed version on page 3, the change, I'll read to you, a minority owner of an employer that demonstrates full delegation of its authority to control day-to-day operations of the employer. I appreciate that amendment, but I'm still very concerned about this for potential investors. I have the wonderful opportunity every year when I come out of here to work with young entrepreneurs in Entrepreneur Day, to work with them on how they can fulfill their dreams. from a standpoint of starting their own business. And usually the story goes like this, that my family doesn't have the money to help me get started. In my particular case, my dad did. And how do I go about doing that? And one of the first things that I advise is take a look at subchapter S under federal guidelines of how to charter your business, or an LLC, a limited liability corporation. Investors like those two vehicles because of the fact that in a startup you're going to have losses potentially, and that can flow through their individual income tax. And when it starts to make money, the business tax liability is taxed at the individual investor's tax bracket, which can also be beneficial from time to time. One of the reasons we select or we look to these types of individuals as investors is that we also want them to be members potentially of our board, because they bring a level of expertise to our business that we treasure. This amendment, unfortunately, does not go far enough and does not clarify if I am, in fact, an investor in that business and I give advice to my young entrepreneur that's running that business, am I now liable under this particular bill? And my answer would be, I don't know. I seriously don't know, because this amendment doesn't go far enough. And the problem with that is, and for any of you that have ever desired to be an entrepreneur or have ever been an entrepreneur, getting the dollars that we need up front to fulfill our dream of the product or service we want to provide is the hardest thing that we have to do, because we have to ask people for money. And that's not easy to do for many of us. So we have to clarify things like that. An investor that is part of this subchapter S or LLC, and you'll notice I didn't talk about partnerships, because partnerships, you are going to be involved in these types of decisions. But a subchapter S, you may not. But it's still not clear, because you're on the board, it's not clear whether you had some influence on the day-to-day operation. That's a real problem. And when there is limited dollars, please understand that we need to do everything we can to help entrepreneurs fulfill their dream. The second concern, and my colleague from Penrose tried to get an answer to this, and I think it's a critical answer. And it's probably in the federal guidelines or in the federal statute on Fair Labor Standards Act of 1938. And so let's just answer it, because the clause reads, nothing in this section, and now I'm on page 4, section 2, nothing in this section authorizes a deduction below the applicable minimum wage. Well, how do I interpret that? I have to do deductions for tax purposes. That's going to take it below the minimum wage, and perhaps that's covered in the statute, so please just answer the question. The second one for me is even bigger. I choose to insure all of the people that work for me. In my particular case, I always paid 100% of the employee, and then I paid a percentage for their family. Well, if I make a deduction for their proportion of the insurance plan, how does that fit under this clause? Now, I look to the attorneys in the room that know these kinds of statutes, but I think that's really important, because if that's, I'm hoping, is in that federal law, All we're asking you to do is answer that, because if that does take it below the minimum wage in a benefit where I'm sharing the cost with an employee, I need to know that, because I could be in jeopardy or again have a liability under this bill. Please, folks, entrepreneurs and small businesses are the heartbeat of this country, and they certainly, I wouldn't be here today without having been an entrepreneur for a long time. We need to be able to answer these questions. We need investor money, and we need to make sure that any deductions we're doing on benefits don't get us in trouble with this bill. Thank you.
Representative Hartsook.
Good morning. Thank you, Madam Speaker. The number one cause for business failures and startups is undercapitalization. That is the number one cause. Small businesses don't have enough money, not only to start, but to maintain payroll and everything else. Colorado, ranking as the 6th most regulated state in the country, is rapidly trying to eclipse that fact and make regulations the problem. Regulations add to the cost of small businesses. Regulations add to the cost of every business, small, medium, large. Medium and large businesses have the capital and the ability to reallocate. Small businesses do not. I served as the business director for a small business before. You work with what you have. The more and more regulations that we pile upon small businesses, and they don't have a whole fleet of accountants and attorneys to look at things, it's general, the person doing the business development and the CEO looking at the contracts, looking at the new statutes that are passed, the new regulations that come out, and trying to figure out how they must comply with that. Classifications out there, there's what's called hub zone. Those are historically underutilized business zones. That's where businesses can go if you've got that designation and you reside in there, that you can provide more money into that community, so you get breaks for that. Service-disabled, veteran-owned small businesses. You have women-owned small businesses and the small disadvantaged small businesses. These are all incentives that the government, both at the federal and state levels, and every state has their different category. These are actual federal classifications, but the states have a corresponding amount that provide incentives to go to work versus regulations like this that inhibit people going to work, inhibit the ability of businesses to get up and running. We should be looking at ways to incentivize businesses, because not only do we hurt businesses, we hurt the very people that they're trying to employ. We hurt the very members in an area that we want to revitalize. If you look in particular at a hub zone, and we actually had a hub zone classification, and we worked at both in Arizona and Colorado, those classifications bring in wages, jobs, and contracts to areas that by definition are historically underutilized business areas, the very people we want to talk about helping. Yet the more we add regulations, the more you make it more difficult to get these contracts, to go in there and compete. Why? If you're curious as to why, what do businesses have to do? They have to pay wages. They have to pay taxes. They have to account for countless regulations that don't even go into actual payroll, but things that they must satisfy, sometimes bonds, all kinds of things that are out there from a regulatory perspective that we keep piling on top of them. At some point, businesses go, I'm done. I'm not going to work. I'm not going to contract. I know we've pulled out of areas when regulations get too thick because it's no longer worth it to compete. Either you raise your prices sky high or you can't compete, or you'll give it over to major corporations that can absorb that and put it under their umbrella. Small businesses are the engine of America. The more we strangle them with regulations, laws, statutes that impede their ability to work with their workers It's kind of like the analogy would be at the municipal level, that's the closest to the people for governing. Small businesses are the closest to the workers that are out there. Are there bad actors? Absolutely. Prosecute and deal with the bad actors. Don't keep passing statutes and regulations that impact the entire small business community and will hurt them going forward and continue to make Colorado harder to do business in. I urge a no vote. Thank you.
Representative Brooks.
Thank you, Madam Speaker. So I have some concerns that I had expressed during seconds. I'm not going to reiterate those concerns. I'm going to set those aside, and I'd like to discuss something that I feel is much more pressing and something that really, the hope resonates. That to be a member of the Joint Budget Committee, you need to be in a little bit of a different area to be able to navigate or be able to really kind of stay in that middle ground. That you can't just simply, from a JBC perspective, come up and just advocate for political positions. The people that are chosen to be on that committee, both sides of the aisle, they're chosen very specifically because they have shown the ability to do that. And I think it's safe to say that they've earned our respect. They've earned our respect to be in that position. I am concerned, deeply troubled, honestly, that a very fair question has been posed, first by a colleague from Penrose, but then reiterated by our member of the JBC. And there has been no movement whatsoever to come here to answer the question. It was a very reasonable question, very appropriately posed, but yet there has been no movement to come answer it. If there is no answer, then what are we doing? What are we doing voting on something if we're unclear on what we're voting on? Are we doing it just simply because we have a duty to punch a button? I would say we do not, and I would say that's very dangerous. If we have a respected member of our Joint Budget Committee that has a legitimate question that is being unanswered, we really need to ask ourselves, are we just punching buttons to punch buttons? Because if there's an unanswered question, I believe that we deserve an answer to it. If there is no answer, I would ask for a no vote.
Assistant Minority Leader Winter.
Thank you, Madam Speaker. I'm not going to litigate this bill. I think the good member from Grand Junction and the rest of my caucus members that came up, they hit on a lot of points, but the issue I have, and I spoke about this on seconds, is putting business names on the internet. If this bill is about making employees whole, but it's also trying to make an example out of these businesses. So if to rectify this, we want to make employees whole, and that's the idea behind the bill. Even though I don't agree with the bill, I understand that point of it. But especially this year, we've seen it more than once. We've seen activist groups come into this building, be against a piece of legislation, and then dox businesses, knock down their Yelp ratings. I mean, it's been in the news, it's been in the newspapers. All of us legislators have been hearing about it. I mean, this could lead to protests at their businesses, their homes. If the goal of this is to rectify an issue of wages between a business and an employee, I think that's what we should focus on. But to put those people's name on the internet, whether they're good or bad actors, and then send people to their homes or their businesses or get on the internet and kill their business on Yelp ratings, I just can't get with that. It's just creating more division and drama. And there was an amendment in seconds where we asked to be able to take this out of the bill. We lost that amendment. But I think it's important to protect everybody. And once again, if the goal is to make people whole, I don't believe that we should be putting these individuals' businesses and names online. for there to be retribution outside of the retribution of the law. And for that reason, I will be a no vote.
Seeing no further discussion, the motion before us is the adoption of House Bill 1001 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Soper, how do you vote?
No.
Representative Soper votes no. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Please close the machine. With 42 aye, 22 no, and 1 excused, House Bill 1001 is adopted. Co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1136.
House Bill 1136 by Representatives Clifford and Bacon, also Senator Snyder, concerning matters related to peace officers.
Madam Majority Leader.
Madam Speaker, I move House Bill 1136 on third reading and final passage.
Representative Armagost.
Thank you, Madam Speaker. I talked, excuse me, I talked a little bit about this yesterday, and my position on this and the other bills varies between the bills that fractured off of what was essentially 1460, House Bill 1460 last year. I think in talking with the bill sponsors through this, I did go through the bill, and the people that came to me on the people that felt ignored last year, the people that came to me with all the information that they had to share or conversations they wanted to share about this bill and the other bills that came from 1460. There were some that I was definitely moved to a support position, and others that I wasn't necessarily there. And this is one of those that I'm just not necessarily there. And the reasons behind that are just the fact that it doesn't undo enough of what was done in years past, not just last year, but with 217 and otherwise. There needed to be a lot more, in my opinion, on what needed to happen with getting the other entities to a support position, but also the fact that I asked to be involved in this last year. I think I'd be in a better place if I was involved in the conversations or if this was a bipartisan bill, and that both of those pieces could have come together to making this what it needed to be. And with that not happening and me just not feeling comfortable, not being in those conversations, not really knowing how those conversations started and ended, I can't be moved to a support position on this bill today, so I will be a no.
Representative DeGraff.
Thank you, Madam Speaker, and I'm kind of in the same place. I've just reading through it again because I really want to be there for the bill. I do appreciate the sponsors. I mean, what started off with a list of inescapable allegations was very, very troubling. So I really do appreciate it that there is now is an escape hatch where somebody can do that. But I think what still bothers me a little bit is that for a peace officer is included in the searchable database can appeal the officer's inclusion in the database. And this requires the disciplining law enforcement agency to provide the post board hearing with all documents relevant to the discipline for which the post officer was placed on the database. So just from a due process standpoint, and the sponsors' explanations were very, very helpful yesterday, but I still am to the point where I think before an individual gets onto a database, before their name is published, before their name is, that all of this needs to be, if there's a possibility of appeal, if there's appeal of something else, then that should occur before that person is even put on. And if I'm mistaken, that would be great to learn. But definitely like the way it's going. Think there's probably some more, maybe there's some more work that needs to be done. Maybe I'm just misunderstanding it. But I think before somebody is deprived of life, liberty, or property, they need to have that full due process action, and that should include the appeal.
Representative Clifford.
Thank you, Madam Speaker. And I appreciate the sentiments. Not voting for this bill doesn't undo that. Not voting for this bill keeps us from having the due process protections that we're putting in this bill. And that's one of the most important things that I think that we look at here. We were not tasked with undoing Senate Bill 217. We sat in a very large working group, sometimes 60 people. Many times there were as many as 9 police chiefs in those meetings at the same time, and we presented a question to them, is this a problem to solve? And then they all worked with us to solve it. The words in this bill are not from Representative Clifford and Rep. Bacon. They came from the county sheriffs of Colorado, the chiefs of police. They came from the district attorneys. They came from the attorney general's office. There is stuff in this bill from the judicial department, from literally we are making post requests in this bill. So this has always been for me about due process for police officers, to make sure that there was an access for them to get resolution if something didn't go right. And I want to address the gentleman from El Paso's comment. You don't end up on the peace officer database by accident. You don't end up on the peace officer database by surprise. Typically, an investigation has occurred and you were part of it. And most of the ways that you end up on there is you were either fired for doing something that gets you on the database, or you resigned in lieu of being fired for something that gets you on the database. And we're not, and nobody in any working group, no police chief, no sheriff, no line level officer, no community member at any point in time asked us to undo the peace officer database. In fact, they said, we want this. We want to make this better. It's working. What we need to do is make sure that we have full process for due process to get people off the database should they think that they need additional due process. And we found some evidence of some times where people were put on the database and we literally could not find a pathway in law for them to resolve it. And that's what we resolved in this bill, and a number of other things. This bill isn't, I called myself the guardrails and the Teflon in the law enforcement working groups. If we've been working through all of these things, there is easily, no kidding, 100 hours of my time in these bills, in this bill alone. Even today, we're still addressing what's in it. So we want to get this right. I want to make sure that you all have your questions answered. And this has been an incredibly thorough process, and I request support from everybody. This is support for our peace officers and making sure that they have what they need to be able to do their jobs well. Thank you.
Seeing no further discussion, the motion before us is the adoption of House Bill 1136 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Soper, how do you vote? Representative Soper, can you hear us?
Yes, I vote no.
I'm sorry, Representative Soper, how do you vote?
No.
Representative Soper votes no. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Please close the machine. With 42 aye, 21 no, and 2 excused, House Bill 1136 is adopted. co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1277.
House Bill 1277 by Representatives Bacon and Joseph, also Senator Cutter, concerning measures to increase transparency regarding the impact of the consumption of certain fuel products.
Madam Majority Leader.
Madam Speaker, I move House Bill 1277 on third reading and final passage.
Representative Barone.
Thank you, Madam Speaker. Good morning, fellow colleagues. I feel like I needed to come back up here. I know we had an in-depth discussion yesterday on this bill, and I still feel like I should come up here and speak a little bit more about it. I really truly do believe this bill is unnecessary and really doesn't do as much as you think it's going to do. It's just going to divide people's points of view on the consumption of fuel products. I spoke a little bit to the sponsor of this bill yesterday that one of my concerns is it's going to mislead the population to thinking that this is the way that the consumption of these products is really still going and is going to be in the future, when we have done leaps and bounds to mitigate the effects of these consumption of these fuel products. Maybe at one point it was to that point where it was concerning, but with all the new technology coming through with car manufacturers, the exhaust systems, and even the fuel itself has been advanced to a point where it's not going to affect environment as much as it did 10, 15, 20 years ago. I gave the example of a lot of people, as you may know, that my profession is oil and gas. I've been in oil and gas for 32 years, and I know the industry. I know how the product is made. I know how the sausage is made, basically. A lot of people ask me about this new drama on TV, Landman. And yes, I've seen it. It's a great show, good drama. But my concern with the show is that it portrays the industry as what it was in the early 90s to mid 90s. It's not a correct portrayal of what the oil and gas industry is now. When I see that show, I kind of get a little worried, because that's not how we work in the oil and gas industry anymore. A lot of what is seen in that show really isn't safe, and there's a reason why we changed the way we work in it. So this is the kind of portrayal I believe that these stickers are going to show the population. If they really want to learn about that product, like I said, it can easily be seen on your phone or by asking for the SDS sheet. All that information is on these SDS sheets. Every gas station has it. I still have my SDS sheet in my personal vehicle for all the chemicals that my vehicle uses and that I have in my vehicle. I believe that there might even be an SDS sheet on gas cans that you buy on the sticker. There might be an SDS informational on those gas cans. So that's the kind of information you can easily, readily available for people if they really want to learn about it. I'm just concerned that this is going to portray this consumption in a negative way to where people think that this is how it is currently and how it will be in the future, when it really isn't that way anymore. I still urge a no vote on this bill. Thank you.
Representative DeGraff.
Thank you, Madam Speaker. So, obviously, we had a good conversation down here yesterday. I just need to make sure I'm all set. There, I feel better. Public is safe. are going to have a bill, ironically, 1177, and this is 1277, and it's an economic development rate tariff in just a little while. And we're going to talk about how it's best to give businesses a break from energy costs because we want to encourage these businesses to come in. Now, a lot of these businesses that are going to come in, we want to come in are the data centers because they seem, and they're massive energy hogs, and apparently we have a plan for lots of them. But we want to give them an energy discount, but yet we're doing things like this that drive up the cost of energy. Now, mostly for the people that can least afford it, the people who have a high energy to income ratio. They pay a lot of their average salary into energy, into driving a vehicle. Not everybody can afford an electric vehicle that has twice the carbon dioxide footprint. Subsidized at about $60,000 per vehicle by the manufacturer, and probably another $10,000 by the state. So if we're going to be, we tried to do some of the truth in advertising yesterday, the truthful aspects of it, and we tried to pass this on to the people who it's a priority. Now, we're looking at the dangers of carbon dioxide, and I looked it up yesterday, and some people will be, and if you're wearing, for the people that are wearing a surgical mask around here, that the CO2 levels in that are 4,965 plus or minus 1,047. So that's instead of 400, so that's about at least 10 times more. 10 times more, 1,000% higher. Yep, there are signs here that encourage people to wear a mask despite the dangers of wearing a mask, which goes back to this. So if we're going to have truth in advertising, we need to be truthful about what we're advertising. And there's a lot of other problems with this, is the signage. I looked at the gas pump this morning. There's a lot of space there, that's for sure. But which is interesting because a gas station is all about advertising. They make very little money on the gas itself. They have to make the money mostly on the inside, advertising on the outside. So, but we're looking at adding another sticker. Is that taking their retail space? I don't know. And then this is all around the idea of climate change, and I went through the actual numbers that are confirmed by the Colorado Energy Office. Now, for those of you who are out there, the Colorado Energy Office has 0 climate goals, none. Nobody in this room has climate goals, none. They have carbon goals, but they have no relation to climate. So let's look at what this is doing, because we want to be truthful with the citizens, and we have to remember that there are over 3,200 billion tons of carbon dioxide in the atmosphere. And of that, Colorado makes about 0.125. Let's just say that it's an entirety of it is gasoline cars, because I don't want to do the math again. So 0.125 divided by 3,200, and carbon dioxide is only at most, depending if you're an adherent to this theory, which really isn't probably true, is about 10% of 40 degrees. And so if you take those out, you get about 4 millionths of a degree. Is what the sponsors are trying to save us from. Just make sure we're doing that right. 0.125 divided by 3,200. Everybody can follow me at home. Multiplied by 4, that's 0.0002. We'll round up just because we're being generous. Degrees Celsius. That's the truth in advertising that we tried to put on there. Now you could divide that by 6 million. And that's 2.6 times 10 to the negative 11. That's the carbon dioxide footprint that everybody in this room has. We want to be truthful in advertising. Is this going to raise cost? Yeah, it could raise cost, and it could eliminate availability. And when it eliminates availability, it raises the cost some more. So yeah, we did spend a lot of time on this, more than a sticker bill. But there's a lot to this bill. This is promoting a superstition No offense to superstitions, they have more mathematical basis than this. But this is promoting a superstition on the backs of the people of Colorado. We're wondering why our businesses are leaving. Why, and when we're the sixth most regulated state, and then we add something like this with potentially with inordinate fines. It doesn't really matter what it is, just inordinate fines. There's no place in the United States that you can go without being bombarded by the superstition about carbon dioxide. No place. It's 100% hammered into everybody. It's the repetition of absurdity for the illusion of truth. It is everywhere. We don't need to burden our businesses with more stickers. We don't need to ask them to put stickers on their machines and then threaten them with fines because they're not adhering to this extra compelled speech. We need to let Colorado businesses breathe. We need to stop moving in making all the wrong moves in all the wrong places with our business community. We need to get out of that space. This room, not good at it. Not good at it. Get the boot off the face of the businesses of Colorado. Vote no on this bill. That's at least that's a positive step in the direction of business and telling people that, hey, maybe we could learn from our mistakes and not chase all the industry out.
Representative Luck.
Thank you, Madam Speaker. I'm not an AI person, but someone sent me something that I think is relevant to this conversation about one of the latest AI models. It's touted as a maximally truth-seeking AI with advanced reasoning capabilities trained on the Colossus supercluster with 10 times the compute of previous models. It's designed to excel in reasoning, mathematics, coding, and real-world decision-making, and includes a think mode for deeper problem solving. It's my understanding that this particular AI tool was given questions related to climate change and the impact of man on it, and it concluded it was filled with all sorts of data from the IPCC and all sorts of other sources, and it concluded that the anthropogenic CO2 global warming hypothesis lacks empirical substantiation, overshadowed by natural drivers such as temperature feedbacks and solar variability, necessitating a fundamental reevaluation of current climate paradigms. So the smartest computer out there right now is saying that perhaps our understanding of climate change is wrong. This bill is grounded on the notion that the current paradigms are accurate, and it's seeking to alter behavior. The information given is supposed to be designed such that the people reading those signs will have a change of heart and possibly pursue other modes of transportation. The question, though, is that a good reason? Does it have a good undergirding? And what is being suggested is no, probably not. Probably our colleague who talks about swimming pools is onto something, and we should listen to him. This sticker, and just for everyone who wasn't in the room yesterday, that has to be on the various pumps at gas stations, must be on white paper with black ink, size 16 font. The language must be in both English and Spanish. If any one of those elements is not present, i.e. the sticker is on beige paper and the ink is navy blue instead of black, the company could be subject to up to a $20,000 fine. Now again, some in the room would say, that's ridiculous. No one would do anything as relates to that. I don't know. Competition in markets can be pretty intense at times, and people can do a lot of things to oust their competitor. But even still, putting that aside, If you are a gas station company with branches in Colorado and Wyoming, and you have dollars to invest in one more station and a good spot in both states, regulations like this are gonna push you to Wyoming and not to Colorado, which means we will have a decrease in the supply we otherwise could have, which means that if our demand stays the same or increases, we're gonna have higher gas prices. And maybe that's great for those who continue to believe the hypothesis that all of this is going to lead to our demise. But for those who don't and who understand the value of transportation for the quality of life and for the betterment of all, that leads to a place that is not thriving. I will say, though, that one valuable aspect of this bill for me personally is I have a dear friend who owns a company in the sticker-making business. And so when this passes through the system, I'm going to inform him that he should create a set of stickers. One sticker that satisfies the terms under this particular bill so he can sell it to all gas stations, and another corresponding sticker that can be added on to the overall package that says, this sticker, some sort of design, an arrow perhaps, says, this is ridiculous. And then both the truth and this bill can be displayed prominently at all gas pumps. Thank you.
Representative Kelty.
Thank you, Mr. Chair. I'm in opposition to this bill, not because of the sticker. Sticker's a sticker. I'm in opposition to this bill because it perpetuates a narrative, a scare narrative that we've heard for how many years? And it cannot go on any further. I have to put my foot down, at least for my vote. People need to understand climate change is normal. Climate change has been happening since the very beginning of the Earth. Now, if you think for a minute that you're going to stop the entire world of climate change with a sticker, that's absolutely absurd. You think you're going to stop all of climate change in the world, period, you've got another thing coming. It's a way to get more money. It's a money grab. It's to scare people into giving money into something that they cannot control and they will never control. We haven't controlled it yet. We're not going to control it going forward. Climate change is a natural phenomenon that happens every single day. The tilt of the earth is something you can't control. I'd like to see you try. Earthquake after earthquake that we have, again, I'd like to see you try that as well. Bills like this do not help inform the public. You cannot control climate change. It's just going to happen. Try controlling the spinning of the earth. How about that one? Is that going to be a bill next? It irritates me when I see things like this that are going off the narrative of fear. You're not, when an earthquake happens, if I can have a little latitude, Chair. When an earthquake happens, like 2012, 2010, change the tilt of the earth. In doing so, it's a thing called butterfly effect. Again, we don't need scare tactics like this bill to teach us this kind of information. Butterfly effect means that places that were frozen are going to thaw, places that were thawed are going to freeze, and in between is going to change. You're not going to change that with a bill on a sticker. You're not going to change it, period. You need to change your thinking and adjusting to what's going to happen, because it's going to happen whether you put a sticker.
Representative Kelty, I've given you a bit of latitude, but let's bring it back to the bill and not be implicating how people are thinking about that bill in this chamber.
Thank you, Mr. Chair. A sticker like this bill, which is what I was getting at, is not going to help anything. And I say this to you as someone who has actually worked in atmospheric science for almost 20 years. We need to stop perpetuating scare tactics like this. I'm asking you to vote no on this bill because it's not going to change anything. It's not going to help anything. It's a feel-good bill for people who feel like they're fixing something which they're not. I ask you for a no vote because I really would like to stop all this ridiculousness. Thank you.
Rep. Garcia Sander.
Thank you, Mr. Chair. So I'm rising in opposition to this bill. What are we doing? When I think about what our constituents sent us here to do, it was really to make Colorado more affordable. It was to make sure that we are educating our kids, and it was make sure that we have our communities safe. I think all of us really campaigned on that last summer, and that's why our constituents sent us here. We talk a lot about the big guy versus the little guy, and one of the things that I've noticed in the last few years is the more regulations we put on our mom and pop gas stations, the more of them that are getting bought out by big corporations, big oil and gas. And so we need to be thinking about that. What are the regulations that we're putting on our mom and pops? There are too many stickers. Somebody approached me in the lobby about this last week. There are just too many stickers on our gas pumps. I don't read them. Who reads them? Nobody reads them anymore. And then when we talk about those being in 2 languages, what about areas that don't have Spanish as a primary language, but have Somali or Hmong or another language as a primary language? If you're going to continue putting stickers on gas pumps, I suggest a smarter way of communicating to people all the information that's on those gas pumps that we don't read anyway. Maybe narrow things down to a QR code where you can update information regularly, where people can access other languages, where maybe if I'm interested in reading what's on the gas pump, the information, the regulations, it's on a QR code, I can zap it with my phone, I can walk away with that information and get all the learning I need, but there are too many stickers on gas pumps, so that's what I'm rising in opposition to. Thank you. I can encourage a no vote on this bill.
Representative Bottoms.
Thank you, Madam Speaker. So on seconds, we ran some amendments to put stickers on things and to educate. And I know that some of them are a little satirical. I didn't get up and speak on those. But some of them were very legitimate. This is, if we're going to use this as an education process, why would we not use them in other settings that are educational so that, you know, the average 17-year-old that's driving behind a bus would know this, or pull into a gas station would know things. So we didn't do that. We didn't accept any of those amendments. If we would have accepted even like one of those amendments, I would feel very differently than I do now. To me, my opinion on this is, and this was driven by a lot of those amendments yesterday, is that this is not about education. This is not about all the things that I'm hearing on the sponsor side of this, but in my opinion, it's about control. We're trying to control, you know, the death by 1,000 cuts. This is the MO of this room, is we're gonna cut here, and I don't mean taxes or finances, we don't ever do that, but 1,000 cuts, one cut here, one cut here, one cut here, a little bit more control here, a little bit more control here, and it literally is a circular concept. It's not about anything but the control. It's not about the stickers. It's about the control. And the more we control, then the more we can control. And pretty soon, you don't even realize that you're being controlled in 1,000 ways. This is the way that I saw this going down, is somebody is sitting at a gas station saying, how can we control more? Well, that's an empty space on a gas pump. Why don't we control using that space? We've got it in 999 other spaces. Why don't we let this be the 1,000th cut? Which I don't believe it is. I'm using that satirically because in this room we do it by a death by 20,000 cuts, 50,000 cuts. And this is just another space that we can say, you know what, people of Colorado, we're going to control you. People of Colorado, this may not seem like a big deal. You're not going to feel it. You're not going to notice it. But it's another tiny little cut. And all of a sudden you're bleeding from that cut, as is the other 1,000 cuts. And you have less
independence, you have less autonomy. You say, it's just a sticker. That's my point. Since there is no valid reason for this sticker, and we proved that yesterday, since there is no legitimate reason for the sticker, there has to still be a reason, because there's a reason for everything. Since there's no legitimate reason that is in one word of this bill, it must be control. That's the only other option I can come up with. And here we go again, people of Colorado, here we go again. Less independence, less freedom, less of your voice, more and more control, more and more control. When do we stop this? When is enough enough? Well, I can tell you there is no end zone, there is no finish line on the left. It's going to continue forever. And we can look at major countries around the world where it never ended until they collapsed. And here we go again. Enough is enough. We've got to reclaim Colorado.
Representative Weinberg.
Thank you, Madam Speaker. With a bill title like that, it seems very hard to vote no. But colleagues, I rise today in strong opposition to 1277. Let me be clear. This bill is not about public safety, it's not about transparency, and it's certainly not about empowering consumers. This bill is about government overreach, plain and simple. 1277 would require fuel retailers across Colorado to slap warning labels on gasoline, diesel, and even biofuels, saying that combustion contributes to greenhouse gas emissions and health impacts. It threatens them with lawsuits under Colorado Consumer Protection Act if they do not comply. And the best part, if they get it wrong, they're subject to legal action, fines, and bureaucratic red tape. Here's the problem. Everyone already knows that burning fuel produces emissions. Coloradoans aren't stupid. They know what goes in their cars. They know what comes out of the tailpipe. Putting a sticker on a gas pump telling them what they already know does nothing but insult their intelligence and burden the businesses that keep this state moving. This bill doesn't reduce emissions. It doesn't improve air quality. It doesn't get a single person out of poverty or a single Coloradoan in a better vehicle. It's a virtue signaling, nothing more, and it does so at the expense of small businesses and consumers who are already struggling with rising costs in the state. Do we want to talk about environmental responsibility? Great, let's do that. But let's do it in a way that actually addresses the root issues: infrastructure, innovation, incentives that help people move forward, not with government-mandated warning labels that accomplish nothing. Let's not turn gas stations into political bulletin boards. Let's not expand state power under the guise of consumer protection when there's no deception happening. And let's not forget that fossil fuels still power over 90% of transportation in Colorado today. Whether you like it or not, families rely on gas to get their kids to school, to get to work, and to keep their businesses running. Punishing them with fear-based labeling won't change anything. 1277 is unnecessary, it's ineffective, and it's out of touch with the real issues facing the good state of Colorado. I urge a no vote, and I ask you to stand with the working Coloradans, not against them.
Representative DeGraff, this is your second time to speak to this bill. You have 2 minutes and 40 seconds remaining.
Thank you, Madam Speaker. So I'll try to speak quickly. I just wanted to put in the rest of this for real intelligence versus artificial intelligence. But and it was brought up about swimming pools. Now, again, the reason for fear is because the psychology of fear is that it brings all your blood to your lungs, your heart, and your major muscle groups, every place but your brain. So the purpose of deriving fear is non-thinking, and we don't want to think. So I'm going to try to give some of you people up there in the audience something to think about. So anyways, if you take Colorado's carbon dioxide production, which is 0.125 billion tons, and you divide it by the 3,200 billion tons in the atmosphere, and you multiply that by the 10% effect that carbon dioxide has on the global warming in the atmosphere, if you don't use the theory of adiabatic pressure, then you divide that by 6 million, what you end up is one half of 1 trillionth. 1/2 of 1 trillionth part. Now, a colleague of mine put me on this analogy, which I really appreciate because it has been very helpful. Because when I asked, I had to ask, how big is a trillionth? So 1 trillion, and we're looking at 1/2 of 1 trillion. Then I thought maybe a trillion drops would fill maybe a half a bathtub or something. But if you go back to your chemistry in college or high school, there's about 20 drops in a milliliter. There's 1,000 milliliters in a liter, and there's about 2.5 million liters in an Olympic-sized swimming pool. So if you go across the entire thing, what you end up getting is 1 trillion drops would fill 20 Olympic-sized swimming pools full of drops. Now, that's a little bigger than a bathtub.
Representative DeGraff, you have 50 seconds remaining, and please bring the swimming back to the bill.
Thank you, Madam Speaker. I'm just trying to bring this back to the truth in advertising as to how much this has to do, the individual's carbon footprint has to do on the climate. And it's 1/2 of 1 drop in 20 Olympic-sized swimming pools full of drops. That is why that is why bills like this drive up the cost of your energy. That's why your energy costs are going up at home. That's why your energy costs are going up for your car. That's why you're being forced to incentivize electric vehicles with your tax dollars and if you buy another vehicle. That's what all this is about. 1/2, 1 drop, 20 Olympic-sized swimming pools full of drops. For the sake of real and artificial intelligence, vote no on this bill.
Representative Bradley.
Thank you, Madam Speaker. I didn't speak on this bill yesterday. Well, I kind of did, but I figured I'd come up to the well. You know, these are the bills that just, they kill my district. They kill my constituents. They ask, what are you guys doing up there? And I tell them, I don't know. I don't know. To me, this is overregulation. To me, being the 6th most regulated state, I have to question, are we stakeholdering the people in Wyoming? Because I feel like we're driving so much business out of Colorado, maybe they're behind the bills. Maybe the people of Wyoming are like, please continue to strangle small businesses and businesses in Colorado, because the more you do that, the more we win. We win on eggs and ammo and guns and fireworks. Keep driving. Keep driving those people out of Colorado, because we are winning in our state. So maybe we should find out if the people of Wyoming are sitting at this table, because I think they might be. 42.8% of 8th grade kids are meeting or exceeding expectations at grade level. So if this bill's to educate, we might want to go to the schools first to make sure our kids can read and write, because they can't. 60% of kids can at 8th grade, and we know at 3rd grade it's way, way, way farther down than that. 60% of kids in 8th grade are not even meeting expectations of 8th grade. So maybe the representative from Fort Lupton has a good point. Let's just do emojis. Let's not put it in English or Spanish, just emojis. Bad, bad, bad. And then maybe everyone can understand. We're driving businesses out of the state, and all of our constituents are begging us to come up here for the 4 months we're here and make our cities and our state safer. Stickers on gas pumps ain't doing it. They want crime to go down. They want public safety to be better. We're the 3rd least safe state. And a sticker on a gas pump, that's what we're going to argue today? Coloradans are done. They get one more sticker on a gas pump, and we can say, yay, we did that in 2025 legislative session. Woohoo. Come on. They want crime to go down. They want public safety to be better. But maybe next year, I'll bring a bill to label child rapists. Vote no on this bill.
Representative Bradley, thank you. Minority Leader Puglisi.
Thank you, Madam Speaker. I do rise because this bill was particularly interesting to me yesterday. I don't sit in committees, and so I don't generally have the ability to hear everything that you all hear. And I spent a lot of time yesterday listening to the members of my caucus, especially the ones who were in committee, to help me understand the bill a little bit better. And I still just, I have some misgivings about this bill that I felt like I really needed to put on the record. You know, in the bill, it talks about natural gas, and in my past life as a county commissioner on the Western Slope, we were working with the Japanese to export natural gas to Asia because they wanted to have a clean source of energy that they could use in Asia. They also did not want to continue to buy products from places like Russia, who were adverse to their geopolitical interests. And so when I read this bill and saw that natural gas was called out, I thought how interesting it was because when we were going through coal transition, especially on the western slope, and throughout southeast Colorado, Pueblo, plenty of places, we talked about clean energy sources. And natural gas, we had to get off of coal to go to natural gas because it was a clean energy source. And now it seems like natural gas isn't clean enough anymore. And so I do take some issue with that because I don't think that nationally or internationally that is the sense. I also am concerned, this says that CDPHE will have in their fiscal note minimal impact on workload, and I'm still just trying to figure out how this works in practice, right? So you go to a gas station and there's not a label, and you send a notice to the gas station and say there's not this label, and then you get to hire an attorney for deceptive trade practices. Somewhere in between, maybe CDPHE is notified and they're gonna have to take a look. I don't think that minimal workload is really appropriate. I do think there would probably be an increased workload by complaints, and especially from people who don't read the bills that we put out here to know what their rights and responsibilities are. Most importantly, I'm concerned about the additional burdens that we are putting on businesses and raising it to the level of deceptive trade practice. I mean, when I think in my mind about deceptive trade practices, I'm thinking about all of the seniors in our communities who are being scammed and are losing their fixed income in retirement. Like, that's deceptive trade practice. Putting these labels, it seems like an overly political statement in a place that I just personally don't think is appropriate. And so I've got some issues with this bill. I think that it is an incredible impact on our businesses. I don't think we are truly thinking about the impacts that this label will bring. And for those reasons, I urge a no vote. Thank you.
Representative Joseph.
Thank you, Madam Speaker. And I just want to thank all our colleagues who came down to speak on Thursday on this bill. Thank you for the robust conversation. I just wanted to add, this is a great bill. The bill sought to drive systemic change by helping us meet our emission reduction goals and help us raise awareness and give notice to community members. I just wanted to speak to some of the comments that were made around the warning label. So I wanted to give you some example as to why a warning label is being enforced by the Consumer Protection Act, like most labels. Colorado Revised Statute 25-17804, brought by Senate Bill 23-253 regarding misleading advertising about compostable products, is also under the Consumer Protection Act. A producer of a product that is not certified compostable shall not market or advertise the product in the state. Along with HB 25-1161, labeling gas fuel stoves is also under the same enforcement statute, which is the Consumer Protection Act. A warning label is similar to any other warning label enforced by the AG. So let's keep in mind that in our bill, we have also granted a right to cure period of 45 days, which is a generous amount of time to replace a $3 sticker. These gas stations also have cameras all over the place. They can prove if the sticker was removed or vandalized. So, and also I just wanted to note that the AG's office only bring about 4 to 6 major cases per year. Again, this is a great bill, and we ask for a yes vote. And again, I'm delighted to be working on this bill with my co-prime sponsor, the good representative from Denver.
Assistant Majority Leader Bacon.
Thank you, members. And, naturally, we always expect conversation on bills like this. I do want to acknowledge my colleague from El Paso County who put a warning on himself talking about emitting gas. I would like to say hot air, and I do believe it changes the climate in this building, so thank you. Sorry. I want to just quickly share, again, a few clarifying points because we've heard this bill, but I want to be clear. So just as my co-prime shared, CDPHE is not involved in this bill. This bill is routed to Consumer Protection, which is the AG's office, and that's why they have minimal touch points in the fiscal note. At the end of the day, nobody has actually said what is on the label isn't true. We have come to that conclusion as a matter of the state legally, and if we go to court, we have a factual basis that is rooted in state and federal findings. Now, do people disagree? Sure. But as a matter of law and fact, we have actually come to determinations about this. And it is defendable. And that is also why it is not a First Amendment issue. The other thing I'd like to just point out is that there are fines and fee structures for the labels that do exist, and none of them have put gas stations out of business. Weights and measures. That's where the costs come from. The percentages of ethanol, that is required. Those are posted. Those aren't, pulled off. And gas stations haven't gone out of business. So what we are doing is what we believe is consistent by way of disclosures. And if we do have higher gas prices in this state, it is because we will need reformulated gas because we have an ozone problem. By the way, and the way that we help that is if our community has to figure out how they are going to balance our interests. It is all of our responsibilities to figure out how to get to the cleanest air. And I will say, and I said it on this microphone, I said it in committee, and we said it in the bill, we have done work to bring down the negative impacts of emissions. We have. I said it here, I understand and deeply value and appreciate the expertise our colleagues who work in the industry bring to us. But even as we saw an amendment, they still emit. It is still a greenhouse gas, and we still have atmospheric issues. We talk all the time about energy, and I can imagine how nervous it makes people, but did we not just discuss nuclear? How much time are we talking about wind and solar? We are at a precipice where we're also discussing these industries and opportunities for investment to build jobs, but also as are connected to our energy needs and our health and climate needs. This is not a new conversation for us. We have been in it for the last couple of years, and this is our generation's question. And in order to have us all decide as a community, as neighbors in this state, we need to be informed. It is atrocious to me to associate knowledge with fear. I am deeply concerned of how many people and how much I've heard from in this building about keeping knowledge from people. And God bless us all, but the CMAS does not assess if you can read or not. And we all know that. That is not what it does. And to suggest that only 40% of this state is literate, that's a whole different problem of saying that if that is not the case. But ladies and gentlemen, we have had restaurants to put nutritional facts and disclosures about caloric intake. I live in a food marsh, which means all I have is fast food. But you know what is sold now? Salads, because we informed people about diabetes. And my blood pressure that's raising right now. God bless, sorry. Okay? So, and you know what? No court called that a taking. That's prime advertising spaces on menus. Nobody has done that before. So at the end of the day, I just want us to say and to know, we are not asking for things that we don't already do here, and knowledge is power. Knowledge is power. People should never be afraid of it. Never. And just because I might live in a neighborhood where I have to fill up my car, because I do, just because I live in a neighborhood where the only place I can get lunch is fast food, doesn't mean I don't want to know. And it also doesn't mean I can't work with my colleagues to figure out how to solve our problem. But we have to know what it is first. I learned something yesterday, and I'm going to get it wrong. SDS, SSS, SDS. SDS. But guess what? I didn't even know to look that up until somebody told me about it. And that's what we're asking for with this sticker. And so again, it's not even a sticker. God, I've already acquiesced to the language, okay? But I just want to say to you all, thank you for listening here, because we put our cards on the table. We put our cards on the table. We do have a context that other states do not have. And I'll say it again. We have oil basin, we have Rocky Mountains, we have parents who got to figure out how to get to work, and parents who got to figure out if they can afford an inhaler. All of those things are decisions we have to make. But again, we cannot do it if we don't know what the problem is. So thank you all for your consideration today. And I hope that as we continue to talk through this, we will treat each other with respect. There is nothing that I believe is ridiculous, at least that I would say on a microphone, because I love you all. But like I said, if I can learn something from you, you can learn something from me, but I hope we can agree that knowledge is always power. And we cannot solve problems unless we know what it is. So I guess this is a pulpit, amen and hallelujah. Thank you. Next time I'll put a sticker on too about gas. But please, members, consider and vote for this bill.
Seeing no further discussion, the motion before us is the adoption of Senate Bill 62 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Forgive me. House Bill 1277. Please open the machine. Representative Soper, how do you vote?
No.
Representative Soper votes no. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Representative English, how do you vote?
Yes.
Representative English votes yes. Representative Valdez is excused with a $10 fine. Please close the machine. With 33 aye, 30 no, and 2 excused, House Bill 1277 is adopted. Co-sponsors. Please close the machine. Members, we are on thirds. Please take your seats. Conversations need to be kept to a minimum. Thank you. Mr. Schiebel, please read the title to Senate Bill 62.
Senate Bill 62 by Senators Hendrickson and Weissman, also Representatives Carter and Gilchrist, concerning contempt of court for failure to appear charges in municipal court.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 62 on third reading and final passage.
Representative Armagost.
Thank you, Madam Speaker. Again, spoke to this one yesterday as well, but this is just something that we all need to realize with everything we have going on in public safety. This is another attempt in softening crime. Failure to appear is a crime. We need to actually maintain or harden those crimes and penalties so that we can hold people accountable, especially when it comes to making it more of a burden on the people that are appearing for jury duty, that are preparing court documents and things like that, all for things to be delayed, especially when it comes down to the victims that are needing to appear in court for these trials. So we need to be holding people accountable for this. We need to maintain, not soften the crimes of failure to appear. We need to maintain those charges as they are or better. So I encourage no vote.
Representative Caldwell.
Thank you, Madam Speaker. I get up here to urge a no vote as well. And I really want to try to nail down what this bill does. This bill takes away the local control from your municipalities to properly hold people accountable, people accused of crimes accountable for not showing up to court. And now we heard stories in committee, and then we heard them yesterday. You know, a father of 8 who just can't make it to court and he doesn't show up multiple times. I think any reasonable judge or whoever's handling the case is going to take that in consideration if you just can't get over to court because you have 8 children, you have a job and whatnot. But the problem that I have and that I continually see between Judiciary Committee and this committee is that we are taking the wants of the criminals, the people accused of these crimes who are supposed to be showing up to court, over the needs of the innocent people. And in this situation, the innocent people are the jurors who have to show up to court to hear this case, and they have jobs, and they have children they have to get daycare for. And they're robbed of that time when the person accused of the crime doesn't show up. The witnesses, same thing. What about the victims? So what we heard in testimony in Judiciary Committee is that this is almost like a loophole, and that if you don't have a victim to show up to testify, then the charges are going to get dropped. So why don't you, if you're the criminal being accused, why don't you miss court 5-6 times in a row? Because guess what? That victim, they eventually get tired of it, and they don't show up because they just assume the person accused of the crime is not going to show up. And then the charges get dropped. And that's what we heard from the experts. We heard that this is more of a legal loophole to get charges dropped. And we're hearing cases of 5, 6, 7 times people don't show up to court. And now we're telling municipalities, oh, you know what? It's not a crime anymore. You can't be charged with contempt for not being there. So for every one person that has 8 kids and they're accused of some crime and they can't show up to court, how many people are taking advantage of the system? How many more are going to take advantage of the system if we pass this bill and we strip away local control for them to be able to hold criminals accountable? We have to stop taking sides of the criminals in this body. That's what this bill does. Hold them accountable. We are in the top 5 for so many crimes nationally. Does this help our crime rate or does it hurt it? It's very simple. Vote no on this bill, please.
Representative Johnson.
Thank you, Madam Chair. I stand in strong opposition to SB 062. This does the opposite of making our state safe. It actually encourages for more unwanted behaviors, more criminal activities. I grew up in an area of accountability. If I messed up, I faced it. I definitely know if you break the law, you should be accountable for that. So why are we in this state making things so much more permissive, so much easier for criminals to get away with things and for victims to not have the justice they deserve? We're already making it hard for our law enforcement community when they go to a crime. What can they actually arrest for now in this state? What can they actually take someone to jail or prison for in this state? And then if they can, how fast is that person who is allegedly in a crime, because I get we are in a state of, innocent till proven guilty, but alleged in a crime, released on a bond just like that. We are making it harder for our law enforcement community to show up to keep our community safe because they're released on bond, and if they're told to appear for a court case, and now it's not a crime not to appear, where are we holding people accountable? Why would anybody be deterred of not having a crime, showing up for bond, and then never coming to the courts? This is the opposite of what I know House District 63 sent me to do, which is for more public safety, to ensure that we are having justice for victims. If you commit a crime, you need to face the heat and the consequences. And if we just say, nah, you're gonna get slapped on the hand because you don't wanna show up and face this, no longer, a penalty, who's going to show up if we're not holding them? Where is the deterrent factor so that way our crimes are not increasing in this state? I strongly urge a no vote because this would do the opposite of what we need here in the state, and that's public safety.
Assistant Minority Leader Winter.
Thank you, Madam Speaker. I don't get home to the district very much during session. Try to spend a little bit of time with my family. But a few weeks ago, we had a legislative breakfast in Pueblo, Colorado. And this bill and a House bill came up. We've discussed the House bill in here already. And this is one of those things where, like I said before, we might all be experts at one thing or another, but at the end of the day, I guess our expertise as we push the button doesn't matter in some instances, yes, but in some, that's when we go back to what our state badge says, and that's to be a representative of the state. We discussed this on a couple bills my first year here about how local communities know what is best for them around certain things. With this breakfast, with about 100 people in there, the mayor got up and spoke against legislation like this. And the room, I'd say, was at least in 90% support. The police chief from Pueblo has come up and testified against these bills. This is a police chief that just saw 3 of his officers shot a couple weeks ago. We took a moment of silence for those officers that were shot. And this goes back to the representative piece. I'm not an expert about this whatsoever, but I listen to my constituents. And when my police chiefs come and say, I can't get with this is what's happening in my city, when a mayor who says the same thing, who was elected by the local people to represent them, and I think that's the point I was trying to make about legislation we've talked about in the past, because our argument was, well, we shouldn't do this, and the argument that was given back to us was, well, if the local elected officials want this, they're closer to the people than we are. I mean, no different than the Senate. There's more counties, so the more responsibility we take on, the more municipalities we look over, the more counties, it does take us farther away from local issues. I mean, Chief Knoller's been in this building quite a bit lately. This isn't a discussion that's new. We had this discussion with him. We actually sat down with him and the DA from Pueblo this last summer and chatted about these issues. And I have the people that are closer to the people telling me that their communities don't want this. And then it comes to the home rule issue. So if they don't want this, they still have to take this. If they see this as an issue in their local city, they can't be any different because this is blanket policy. So if they believe this is creating problems for law enforcement, there's no recourse for them. They just have to jump in line. So like I try to say all the time, I represent people. And when I have elected officials in my district who are elected by a large body of people to represent people coming and saying that this isn't good for our community, this isn't good for our city, we think it's going to hurt more than it's going to help, I would be remiss if I didn't come up here and express those concerns. I just try to listen to them. And for those reasons, for people like Chief Knoller, who has to talk to these families and see their officers shot up in hospitals, it isn't because Representative Winter wants to vote no on this. I'm voting no for them. Thank you.
Representative Garcia Sander.
Thank you, Madam Chair. So, as mentioned before, just a minute ago, local control is really important, and I think when we take this and make a blanket rule for the entire state, we're not doing what our constituents all sent us here for. As a principal of an elementary school, and sometimes I would have to give consequences to students. And sometimes that might be, wow, you made a mess in the lunchroom, so now you owe me 15 minutes of cleanup for the next lunch. Or, you weren't very nice to your friends out on the playground, so I want you to come in and spend 5 minutes with me talking about how we treat our friends on the playground. Failure to appear meant I would double that time. So if they were like, oh, I forgot, I just went outside anyway, and that 5 minutes that I owed you, I forgot, I went out and played anyway. Well, actually, you owe me 10 minutes then. And we would have that conversation. I would tell them up front, don't forget, because if you forget, and they would always say, I know, you'll double it. It would only happen once. So we're talking about behavior modification. I think when we have consequences for behavior, it modifies our behavior. Those can be good consequences or bad consequences. I think failure to appear needs a consequence, doesn't have to be the end of the world, as I would tell my students, but there does need to be a consequence because that does modify behavior, and that's what we want in the end, is to have people modify their behavior for the good. So I encourage a no vote on this. Thank you.
Representative Byrd.
Thank you, Madam Speaker. Members, I don't come often on third reading to come and speak, but did want to on this particular piece of legislation. I think for most of you who know me, you know that public safety is one of my top legislative priorities. Making sure that we are keeping our community safe and holding people appropriately accountable when things happen in our communities. I think that's important, and it should be a priority for every one of us. With respect to this bill, what this bill is doing, and I'm rising in support of this bill, what the bill does is ensure that if a person has received a citation or a ticket for something in and of itself that is not an offense for which you could be jailed, it doesn't seem right that you would then find the opportunity to jail that person for failing to appear. Judges have other tools to compel people to come and be accountable and responsible to the harms that they've committed, but not through violating their liberty. If we're going to deprive someone of their liberty, we need to follow good constitutional principles, make sure we're respecting those foundational principles that we all swore to uphold, and do this the right way, but don't jail somebody for failing to appear when their underlying offense didn't require jail in the first place. So I'm urging a yes vote.
Representative Clifford.
Thank you, Madam Chair. Madam Speaker, my goodness, habits. I'm in support of this legislation, but I also want to discuss some of the things that got said here. This is about municipal court. This is about $1,000 fines, up to 6 months in jail. This is not about police officers getting shot. This is not about a reduction in crime. This is not any of those things. And I keep hearing us pile on things that sound like public safety and pile it on to things that are not at all what we're talking about. And it harms us. And I appreciate Chief Knoller, I really do. But, I looked at the crimes that those people had been charged with, and it was not, I disagree with the notion that the crimes don't exist. I do agree that the district attorney has the ability to charge them, and the district attorney has the ability to accept the deals. We're not talking about people getting shot when we're talking about charges in municipal court, and I would really like for us to pay attention that we're separating and talking about the lanes that we're in when we're discussing legislation. And, that this bill is not that. Thank you.
Seeing no further discussion, Assistant Minority Leader Winter, this is your second time to speak. You have 6 minutes and 23 seconds.
Thank you, Madam Speaker. I only voiced what the chief said himself. We can have all the respect for people in the world, but we don't listen to them. Those are hollow words. I was elected to represent people, not know better than people. Thank you.
Seeing no further discussion, the motion before us is the adoption of Senate Bill 62 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Soper, how do you vote?
Yes.
Representative Soper, you are on mute.
Oh, yes.
Representative Soper votes yes. Representative English is excused. Representative Wilford is excused. Please close the machine. With 40 aye, 21 no, and 4 excused, Senate Bill 62 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to Senate Bill 60.
Senate Bill 60 by Senators Catlin and Roberts, also Representatives Clifford and Armagost, concerning expanding the crime of obstructing government operations to include the repeated calling of public safety emergency entities without justifiable cause.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 60 on third reading and final passage.
Representative Armagost.
Thank you, Madam Speaker. This came from the Senate as a good bill. This was, the intent of bringing this bill forward was for a good cause. Hearing this in committee, hearing the chiefs, the dispatchers, everyone that came out and spoke in favor of the bill, talked about experiences they had where this was an impact, a serious impact on their agencies. And specifically, one thing that stood out to me was when Deputy Chief Reeves spoke about his time working in the murder investigation of Jessica Ridgway in Westminster in 2012, and how resources were pulled away from people just calling 911 constantly with false information and taking resources away from the investigation with the false information that was actually diverting them and delaying and prolonging the investigation. So all the things that came about, this is something that is definitely necessary, especially myself working with dispatchers, both in fire and in law enforcement, but sitting next to those dispatchers while they were on the job and hearing the things that they had to filter through and the abusive calls they were getting from people, just the random things that people would call and do or say or report. It's something where we do need to have people held accountable. So I do like the bill. I like that the bill was bipartisan in the Senate, and I think this bill needs to be bipartisan in both chambers. So this morning I spoke to the Senate, asked to be added to it, and thankfully am. I think this bill needs to go forward as is in a bipartisan manner, and I encourage a yes vote. Thank you.
Assistant Majority Leader Bacon.
Thank you, and also apologies for speaking after a potential sponsor of the bill. I just wanted to add to the record, just for part of what this conversation is, in case it does come up for a reference from intent from the legislature. We've actually seen a few bills that impact the obstruction crime, and I do want to encourage all of us to get on the same page of where obstruction becomes either, that nuisance calls to 911 operators becomes obstruction. I think there are other industries and other spaces where we have talked about obstruction and made it a different level of crime. And so I do feel like there could be a good effort in streamlining that statute. The only thing that I just want to say here is that when in the words it says repeatedly, technically speaking, that means more than once. And so on the record, I do want to acknowledge that all the folks who came to committee did not intend for people to have law enforcement come up to their house if someone calls more than once in a day. And I think that's really important to say in case that may come up later. And so while law enforcement shares that they typically do not arrest on misdemeanors, it doesn't mean that they can't. And M2s actually do come with jail time. And so what we don't want is someone who is afraid. And I gave the example of someone who believed they were stalked and they've called law enforcement out and no one was there. They might call again, and then a third time they're afraid to call. That's what I'm concerned about with repeated. And so I didn't get a chance to come here yesterday, and I did talk to the sponsor about it, but could we be clear on what we mean about repeatedly? We heard the 911 dispatchers talk about 4,000 calls in a term that was called nuisance calls, and I think that is a little bit clearer when it comes to enforcement. And so, since this is a Senate bill, we are the second chamber, and we weren't able to add that. I wanted to lay record. Like I said, I've heard a version of this bill now 3 times to where this was the issue. The issue is not disagreeing that people hold down the 1 button and call 911 4,000 times. That is not the issue. The issue with 911 is having people building confidence enough to call it and balancing that discretion so that they're not afraid to do so. And so if we could be clear on what the expectation is around repeated calls, I think it would be helpful for the legislative and legal record. Thank you.
Representative Armagost, this is your second time to speak. You have 8 minutes, 16 seconds left.
Thank you, Madam Speaker. And in response to that, I think in the discussions that were had in committee, it is a valid concern based off of some of the language that was exchanged. But I can tell you from my experience, I have all the faith in the world in our emergency communications specialists. They wouldn't be pushing anything on charges for somebody that just calls multiple times because they aren't getting a response. It's going to be the one that's calling with the abusive language or the thousands of phone calls that are going to do that. So I appreciate it, but I don't think that would be an issue on this, and I encourage a yes vote. Thank you.
Seeing no further discussion, the motion before us is the adoption of Senate Bill 60 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Soper, how do you vote?
Yes.
Representative Soper votes yes. Please close the machine. With 51 aye, 11 no, 3 excused, Senate Bill 60 is adopted. Co-sponsors. Please close the machine. Mr. Schiebel, please read the title to Senate Bill 73.
Senate Bill 73 by Senators Liston and Marchman, also Representatives Kelty and Martinez, concerning enhancing support for military-connected children with disabilities who enroll in Colorado schools.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 73 on third reading and final passage.
The motion before us is the adoption of Senate Bill 73 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Soper, how do you vote? Representative Soper, please unmute yourself if you can hear us. Representative Soper is excused. Oh, wait.
Nope.
Representative Soper, how do you vote?
Yes.
Representative Soper votes yes. Please close the machine. With 62 ayes, 0 no, and 3 excused, Senate Bill 73 is adopted. Co-sponsors. Representative Soper, co-sponsors. Please close the machine. Madam Majority Leader.
Thank you, Madam Speaker. I move the following bills be added to the special orders calendar on April 2nd, 2025 at 11:39 a.m. House Bill 1273, House Bill 1177, Senate Bill 172, and Senate Bill 143.
Seeing no objection, the bills listed by the Majority Leader will be added to the special orders on April 2nd, 2023 at 11:39 a.m. Representative Clifford. Members, you have heard the motion. Seeing no objection, Representative Clifford will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there's a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen on iLegislate and in today's folder on your box account. Bills will be laid over upon motion of the Majority Leader. The court rule is relaxed. Madam Majority Leader.
Thank you, Mr. Chair. I move to lay over House Bill 1174, House Bill 1300, and Senate Bill 63 until tomorrow.
Bills will be laid over until tomorrow. Mr. Sheba, please read the title of House Bill 1273.
House Bill 1273 by Representatives Basenecker and Woodrow, also Senator Ball, concerning requiring certain municipalities to modify building codes to allow 5 stories of a multifamily residential building to be served by a single exit.
Mr. Speaker Pro Tem.
Thank you, Mr. Chair. Honor to serve with you.
And an honor to serve with you, sir.
I move House Bill 1273 and the Transportation, Housing, and Local Government Committee report.
To the committee report.
Thank you, Mr. Chair. I move L13 to the committee report.
That is a proper motion. We'll wait for it to be displayed.
It never stops.
Please proceed.
Thank you, Mr. Chair. Just a technical fix to a missed reference in the committee report. We ask for a yes vote.
Thank you. Seeing no further discussion on Amendment L13 to the Transportation, Housing, and Local Government Committee report, the question before us is the adoption of the amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment passes. To the committee report. Mr. Speaker Pro Tem.
Thank you, Mr. Chair. In the committee, we adopted roughly 10 separate amendments, all related to safety. We ask for a yes vote.
Seeing no further discussion on the Transportation, Housing, and Local Government Committee report, all those in favor of adopting the committee report say aye.
Aye.
All those opposed, no. The committee report is adopted. To the bill. Representative Woodrow.
Thank you, Mr. Chair. It is an honor to serve with you.
It is an honor to serve with you. Just 1 second, sir. Thank you. Please proceed.
Thank you, members. I would also like to thank my co-prime sponsor for his leadership on this important bill. I want to thank all the public safety professionals who have met with us on this bill for their commitment to public safety and their interest in finding ways to help address our housing shortage. I also want to give a special shout out to Representative Valdez for his leadership on the issue of Smart Stair last year, getting us to this point. Members, my district and the state of Colorado as a whole is in a housing crisis. To buy a medium-priced home, which is $550,300, and avoid being cost burdened, a household must earn $129,178 annually. We should seek any and all measures at our disposal to reduce the cost of housing and reduce the cost of living for residents. Here in Denver, there are many small lots that don't allow for typical 2-stair apartment development, and where land is so expensive that it doesn't make financial sense to only build a single-family home or a duplex. Smart stair buildings can enable more infill and transit-oriented development on small lots, which can significantly reduce transportation-related greenhouse gas emissions from new development by allowing more people to take advantage of living close to transit options, cutting down on vehicle miles traveled. As my co-prime will get into, smart stair design allows for greater flexibility to provide multiple bedroom units, which is critical to providing more options for multi-generational families or families with multiple children. These families may not be able to afford a single-family home, which is often the only other way to have more than 2 bedrooms. Moreover, small multifamily housing also uses less than half the amount of energy as a single-family home, and smart stair design can allow for natural cross-ventilation and lighting through individual units, reducing cooling costs by up to 80%. Taken together, all of these benefits mean that smart stair buildings can allow for more units on small, challenging lots that are more affordable to build and are more affordable for residents long-term due to reduced utility costs and likely increasing transportation options. This is all while we included vetted safety measures to ensure residents and emergency responders have the same or greater level of protection as any other residential building. In a year with limited financial resources, we must find more policy levers to expand our housing options. This bill seeks to do just that by making it easier to build small apartment buildings on small lots. Again, I thank everyone who's engaged on the bill. I thank my co-prime, and I thank you for your consideration. On 1273, I ask for an aye vote.
Mr. Speaker Pro Tem.
Thank you, Mr. Chair. As my co-prime mentioned, Colorado is indeed experiencing a housing crisis, and it's my belief that we need to use all tools available to us to make sure that we are building a variety of housing on the housing continuum. This bill in particular will make it easier to build small apartment buildings up to 5 stories served by a single exit stairwell that can have 2 to 4 bedrooms, offering a more affordable point of entry for family living. I want to talk briefly about the bill in terms of safety and really thank those who came to the table starting back in June of last year to be able to solve an issue that is top of mind for all of us, and that is providing safe and affordable housing for folks in our communities that is so desperately needed. Allowing smart stair buildings in the most urban areas of the state, and I would note that the bill is limited to jurisdictions of 100,000 or more, can help us address our housing crisis. Infill development in particular can be very challenging because land is in short supply and existing development constrains site designs. Typical apartment buildings with 2 staircases simply require larger building footprints and drastically reduce design options. In addition to that, the land acquisition costs for a typical dual-loaded corridor can add up to 40% of the project cost, and that second staircase alone can add up to 13% of this project cost. So if we want to talk about building more affordable housing in the state of Colorado, one way that we can do that is from smart design from the beginning and not involve state or federal or local dollars in the project as a result. Smart stair buildings offer more flexible designs that can be built with smaller footprints, which reduce the overall construction costs. Current building code requires a central hallway connecting those 2 exit stairs, which effectively bisects the building, resulting in more studio and 1-bedroom apartments. This is a way to build and house families in our communities. This flexibility can dedicate more interior space to larger family-sized units. It also adds more flexibility while common sense safety measures are in place, ensuring that residents and emergency responders have the same or greater level of safety as they do in any other building served by 2 stairways. We would ask for your yes vote on the bill.
Representative Barone.
Thank you, Mr. Chair. I come up here today in support of this bill. I listened to this bill in House Government and the local transportation, local government committee. We see many housing bills, but this one can have a positive impact on housing. I want to touch on this a little bit, that this is not to the point where I would expect it to be for affordable housing, but it is a small step forward, in my opinion. Giving people options for floor plans for their purchases is a great value to this bill, and that's why I'm in support of it. We heard supportive testimony from a diverse set of witnesses, including home builders, realtors, downtown Denver partnerships, and architects. This bill will actually just affect communities over 100,000 people in population. My community, in my district, the only municipality in my district that would affect this would probably be Brighton, but it's something that gives Brighton an option to do this as well. However, the most impactful testimony related to the safety of these buildings, though, came from Mark Chubb, a former fire chief from Seattle, where they have a single stair building and is currently a fire safety consultant. He shared that since the introduction of the single stair code requirements in the mid-1970s, Seattle has experienced no evidence the residents of the buildings experience more fires or more severe outcomes than residents of other multifamily buildings. There's also no evidence fires is near the single stairway have led to fatalities or injuries. The enhanced fire safety features of these buildings have prevented fires from spreading within the stairway and provided ample protection without compromising resident safety within their units. I urge an aye vote on this bill, and I'm in support of it. Thank you.
Seeing no further discussion, the question before us is the adoption of House Bill 1273. All those in favor say aye. Aye. All those opposed, no. The bill passes. Mr. Shebel, please read the title of House Bill 1177.
House Bill 1177 by Representative Morrow, also Senators Henriksen and Pelton B., concerning adjustments to the economic development rate tariff.
Representative Morrow. Thank you, Mr. Chair. I move House Bill 1177 in the committee report. To the committee report. Thank you, Mr. Chair. I move L007 to the committee report and ask that it be properly displayed. One moment while we get that displayed. L7 to the Energy and Environment Committee report. Please proceed. Thank you, Mr. Chair. This is just a technical amendment to fix some language in the committee report, and I ask for an aye vote. Seeing no further discussion on Amendment 7 to the Energy and Environment Committee report, the question before us is the adoption of the amendment. All those in favor say aye. Aye. All those in favor say aye. All those opposed, no. The amendment is adopted. To the committee report. Representative Morrow. Thank you, Mr. Chair. We had a robust discussion in committee, and we did have a few amendments, and then now including this one, and we think we really got this bill in a good place, and I ask for an aye vote. AML winner.
Thank you, Mr. Chair. We had a good, robust debate in committee, but we also had our people come here and testify. And one thing that we know is we need more economic development in southern and southeastern Colorado. I think this is really good for the people of Pueblo. They want to see new businesses come in and help their community rebuild and thrive. So with that being said, happy to be on this bill with my co-sponsor. It's good for Pueblo. It's good for southeastern Colorado. So I urge a yes vote.
Thank you. We are still on the committee report. Is there any further discussion on the Energy and Environment Committee report? The question before us is the adoption of the committee report. All those in favor say aye. Aye. All those opposed, no. The committee report is adopted. To the bill. Representative Morrow. Thank you, Mr. Chair. So as my co-prime, and I'm delighted to be on this bill with him because we share trying to get economic development in southeastern Colorado and Pueblo. We share those goals. So what this does is allows for your community to hopefully help out in some areas of reducing costs for economic development coming into your area. What it doesn't do, and I want to just say this out loud, it doesn't do anything for data centers, which I heard earlier today. We're trying to attract jobs for people so they can raise a family, live in our communities, go to our schools, and be a part of our southeastern area. So I'm fully supportive of this, and this is the kind of bills I want to spend my majority of my legislative time is helping to grow economic development for Pueblo and southeastern Colorado, and I ask for an aye vote. Representative DeGraff. To the bill.
Thank you, Mr. Chair. And the data centers are a question that I'm getting a lot of from constituents, mainly, I guess, along the lines of why we have these favorable energy rates, which is good for business. I think we should look at these favorable energy rates and we should say, hey, if it's good for a big business that comes in, why are we not doing across the board energy rates that incentivize all businesses? Because I understand some of the arguments are that the smaller ratepayers won't pay more and all that, but the perception is and perception is reality in most cases. I mean, it's not necessarily reality, but it's certainly their perception of reality is what they see is with these large businesses that are incentivized to come in, they're like, well, hey, we've been here this whole time. Why are we not being incentivized to stay? Why do you have to be a big business to come in here? So I do think we need to lower our energy costs in order to help business, to incentivize business. I'm just not really sure up to the point, why are we giving an advantage to certain groups? Are they? And then the data centers are a concern. I mean, there's the data centers are They're popping up all over the place, hundreds of them that, that they say, well, we're just going to do, a small footprint over here, and then they add a couple, double or triple the size even. And then these data centers are taking up large amounts of energy and then large amounts of water. And we know that there's the incentivization to bring these data centers in to maintain all of our data forever. I'm not sure why exactly we want that. So when you say it does not incentivize or bring data centers, are you saying that it disincentivizes the data centers, or it's not specifically for data centers? And then why are we not focusing on lowering our energy costs across the board so that we can get the burden of energy off the backs of the rest of the citizens?
Representative Morum. Thank you, Mr. Chair. The reason why this isn't for data centers is because this maxes out at 40 megawatts and data centers need much more than that. So this is truly honed to try to attract businesses that have employees, because that's what we're looking for. We're not just trying to have cheap electricity. And I can assure you that my area is doing everything it can to reduce our energy costs, and I ask for an aye vote.
AML Winner.
Thank you, Mr. Chair. And as talking about this bill, we also, in discussions, were told that you'll have the trickle-down effect. So as these businesses move in and they're buying more electricity, those rates will trickle down into even homeowners. So this will actually reduce costs as these businesses come in. And that's always a good thing. When a new business comes in, they bring jobs, they create industry, they bring in a tax base, and then at the end of the day, as they buy into more power, those benefits start to trickle down and make energy cheaper for the community.
Representative Martinez.
Thank you, Mr. Chair. It's an honor to serve with you.
It is an honor to serve with you, sir.
I'll keep it short and simple. I think this bill is great for Pueblo. It's great for rural Colorado. I urge an aye vote.
Representative DeGraff.
One more question on here. How does this work with our energy goals? Because we are, not that I think there's any credence to them. I think they're nonsense. But when you get into the climate goals, since they don't exist anyways. But when we're looking at decreasing our energy use and then we're encouraging large businesses, which is what we should do, how are these larger energy footprints being compensated so that we're not just then asking the citizens of Colorado to reduce their energy use even more in order to accommodate larger? So are these newer projects exempted because we're supposed to, for whatever lunacy, we're supposed to try to get our energy below like 2005 levels? So how does that work with encouraging these large energy projects to come into the state? I'm for bringing the large energy projects into the state. I just don't want to have it taken out on the back of the citizens.
Seeing no further discussion, the question before us is the adoption of House Bill 1177. All those in favor say aye. All those opposed, no. House Bill 1177 is adopted. The committee will stand in a brief recess.
Mr. Schiebel, please. We already do that? Oh, we were in recess. Committee will come back to order. Mr. Schiebel, please read the title to Senate Bill 172.
Senate Bill 172 by Senators Carson and Sullivan, also Representative Clifford, concerning clarification of the conditions under which an uncontested election in a special district director district may be canceled.
Representative Clifford.
Thank you, AML Bacon. I move Senate Bill 172.
To the bill.
This bill is to correct something that we didn't do when we set forth special district elections. We allowed special districts to not have elections if there is no contest in the election, which happens from time to time when there just is no contest. So if there's no person running or if there's a single person running, just so you know, this does not impact write-in candidates because in this state you have to register as a write-in candidate. You actually have to acknowledge your intent to be a write-in candidate. So this does not eliminate, impact, cause anyone not to be able to run for office should they see fit to do so. But if no one runs against someone that has been standing in a seat, or if only one person is running, we don't have them pay the cost of having to do all the ballots, et cetera, for very similarly poised districts if they currently are by the whole district, so at-large seats. This corrects or clarifies the current language in that law, which there has been some question about, that says that this also impacts special districts where we vote by district. That is something that happens at the South Metro Fire Protection District, which I represent. Those are district-led seats because that's a 500 square mile. It's a very large district, and we vote basically by your local jurisdiction. I have always joked with the person that has been a longstanding member in our district and does an extraordinary job. Every time I bubble in his name on the ballot all by himself, I send him a picture and said, "You won." But I also question why we spent, you know, a very large sum of money to make sure that I had the opportunity to do that when he had already won that election. So this is to correct something that seemed minor in law that needed a clarification, and that's specifically what this does.
Minority Leader Puglisi.
Thank you, Madam Chair. I stand in support of this bill. We saw this a lot in especially the rural areas of the state. So while I appreciate this particular metro district or bigger district, we see that a ton in small water districts, fire districts, all throughout the state where they have to mail out ballots. There's only one person running, and it's costly and time-consuming for these very small districts. And so I stand in support of this bill and really appreciate the bill sponsor bringing it forward. Thank you.
AML Winter.
Thank you, AML Bacon. I also stand in support. This is a big issue that we face in rural Colorado. It's hard to get people to be able to step up and do these things between kids and school board meetings and everything that rural Coloradans do. I think this saves these districts money, and I think it resolves a lot of problems and allows things to go smoother, get things going and actually let people get to work instead of spending so much time on the clerical part of this. So I urge a yes vote. Thank you.
Is there any further discussion on Senate Bill 172? Seeing none, the question before us is its passage. All those in favor, please say aye. Aye. All those opposed, please say no. 172 is passed. Mr. Schiebel, please read the title to Senate Bill 143.
Senate Bill 143 by Senators Doherty and Lundin, also Representatives Armagost and Carter, concerning the limited use of facial recognition services by schools.
Representative?
Wait for it. Wait for it.
Thank you, Mr. Chair.
Hold on. There we go. Representative Armagost.
Thank you, Mr. Chair.
was speaking. Thank you.
Senate Bill 143 in the committee report.
To the, there is no committee report. To the, move the bill.
I move Senate Bill 143.
To the bill.
I move amendment L13 and ask it to be displayed.
That is a proper motion. Representative Carter, 1 second. We will get that amendment displayed. To Amendment 13, Representative Carter, it is displayed.
Thank you, Mr. Chair. This bill has been stake-held since its beginning. My understanding, its impetus actually started before I was actually in this building. Representative Armagost, as well as the members of the Senate, have been working on this bill. This amendment only adds ECE, aka those entering kindergarten and fifth grade or below, to the list. Only adding just one piece that we had forgotten. We reached out to some other stakeholders. We spoke to the specific senators on the bill. They were fine with it. And so we're just adding that, we're asking that this piece right here be added specifically to the bill.
Representative Armagost.
Thank you, Mr. Chair. So the stakeholding that went on mostly happened in the Senate. We had one that was lingering when it got to the House, and this was actually in my House district. So I'm happy that they were willing to accommodate and make those amendments for the school districts that had that. The biggest concern was involving pre-K, not just K through 12. So this amendment adds pre-K, and I think this is a good thing. Encourage yes vote.
Thank you. The question before us is the adoption of Amendment L13 to Senate Bill 143. All those in favor say aye.
Aye.
All those opposed, no. The amendment is adopted. To the bill. Representative Armagost.
Thank you, Mr. Chair. This bill is taking the facial recognition out of just the general use in our schools for kids. This is something that I think it helps maintain the privacy of our kids. There's not just something, any kind of loose database that's floating around there with our kids' facial recognition data and biometric data. So this bill, as amended, only applies to emergency situations. So in the case of an emergency, there's a threat to the school or there's a missing kid in the school, then they are able to obtain a picture and utilize the facial recognition only for those means, not for any other means, just for general purpose or general use. So this is something that isn't an all-out prohibition or all-out ban on facial recognition, but it's specifying only in those emergency cases. So I think this is, the way it's come through, this is a great bill, and I encourage a yes vote.
Representative Carter.
Thank you, Mr. Chair. I'm in agreement with Representative Armagost. I know you're not listening because y'all didn't hear that. I'm in agreement with Representative Armagost. One of the things this bill does is there is a sunset clause in the original bill. If we were not to do anything, if we were not to add these the continuation of what's already going on with these specific amendments, then school districts there would be no rules regarding what they could do with this information. As I've indicated many times, I have children in schools, I have a wife in school. It is about their privacy and their protection, and so that's why I'm on this bill.
Seeing no further discussion, the question before us is the adoption of Senate Bill 143 as amended. All those in favor say aye.
Aye.
All those opposed, no. The bill is adopted. Madam Majority Leader. Oh, here she comes. Hey.
Thank you, Mr. Chair. I move the committee rise and report.
The committee will rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being the second reading thereof and making the following recommendations. They're on House Bill 1177 as amended, 1273 as amended, passed on second reading, order engrossed and placed on the calendar for third and final passage. Senate Bill 143 as amended, and Senate Bill 172 passed on second reading, order revised and placed on the calendar for third reading and final passage.
Representative Clifford. Members, you have heard the motion. There are no amendments at the desk. The motion before us is to adopt the report of the Committee of the Whole. Mr. Shebel, please open the machine, and members proceed to vote. Representative Soper, how do you vote?
No.
Representative Soper votes no. Caldwell is the last one. Please close the machine. With 41 aye, 22 no, and 2 excused, the report of the Committee of the Whole is adopted. Madam Major... Oh, message from the Senate.
Madam Speaker, the Senate has adopted and
Message from the
transmits.
Senate will be printed in the Journal. Introduction of resolution.
Senate Joint Resolution 18 by Senators Winter and Frizzell, also Representatives Duran and Puglisi, concerning Sexual Assault Awareness Month and in connection therewith, recognizing April as Sexual Assault Awareness Month and designating April 30th, 2025 as Colorado Denim Day.
Excellent. Madam Majority Leader.
Thank you, Madam Speaker. I move to proceed out of order for consideration of resolutions.
Seeing no objection, we will proceed out of order for consideration of a resolution. Madam Majority Leader.
Madam Speaker, I move to suspend the rules for immediate consideration of Senate Joint Resolution 25-018.
The motion before us is to suspend the rules for the immediate consideration of Senate Joint Resolution 018. Oh, we do. I was just going to ask for acclamation, but we do need a recorded vote. Mr. Shebel, please open the machine and members proceed to vote. We do need 2/3 of the body to approve the motion in order for us to suspend the rules. Representative Soper, how do you vote?
Yes.
Representative Soper votes yes. Please close the machine. With 63 ayes, 0 no, and 2 excused, the motion to suspend the rules is adopted. Madam Majority, Mr. Shebel, please read the title to Senate Joint Resolution 18.
Senate Joint Resolution 18 by Senators Winter and Frizzell, also Representatives Duran and Puglisi, concerning Sexual Assault Awareness Month and in connection therewith, recognizing April as Sexual Assault Awareness Month and designating April 30th, 2025 as Colorado Denim Day.
Madam Majority Leader.
Madam Speaker, I move for the adoption of Senate Joint Resolution 18 and ask for it to be read at length.
Mr. Shebel, please read our resolution.
Whereas Sexual Assault Awareness Month officially began in 2001, though the movement to raise awareness for and put an end to sexual violence can be traced back much further. And whereas decades of activism and persistence by survivors and advocates led to the founding of the first Rape Crisis Center in the United States in 1971, and the passage of legislation and funding to support survivors, including the Violence Against Women Act of 1994. And whereas the Denim Day campaign was originally spurred in 1998 when the Italian Supreme Court overturned a rape conviction after the justices believed that because the victim was wearing tight jeans, she must have helped her rapist remove her pants, thereby implying consent. And whereas the following day, women in the Italian parliament came to work wearing jeans to show their solidarity with the victim, and the following year, the Denim Day campaign began in the United States, where participants are encouraged to wear jeans, symbolizing a protest against attitudes condoning sexual assault. And whereas the Colorado Coalition Against Sexual Assault has served as the collective voice for sexual assault survivors and service providers in public policy initiatives, education, training, and collaborative efforts for more than 4 decades. and has worked with the Colorado General Assembly to pass laws that provide protection and support for survivors of sexual assault. And whereas since 2013, the Colorado Coalition Against Sexual Assault has hosted Colorado Denim Day, thereby continuing the movement of political representation for sexual assault survivors and bringing necessary awareness toward the issue of sexual assault to the Colorado community. And whereas the Colorado Denim Day 2025 theme is "Denim Isn't Always Denim, Believe Survivors Act Together, Prevent Violence," highlighting the importance of recognizing the vulnerable communities face increased risks of sexual violence due to their intersecting identities. And whereas supportive services are a critical mechanism to stabilizing and supporting survivors, and service providers across Colorado continue to face funding cuts and threats to programming, especially cultural-specific services and those in rural communities. And whereas few resources are allocated to preventing sexual violence, yet primary prevention strategies promote safe and more supportive communities for all. And whereas Denim Day is an opportunity to bring attention to the failures of the legal system to take sexual assault seriously and support survivors, such as the current sexual assault evidence kit backlog in the Colorado Bureau of Investigation that has left survivors waiting, on average, 560 days to receive results and obstructed survivors' ability to seek justice, safety, and healing. And whereas continued action is needed to further expand support services, treat survivors with respect and care, and prevent sexual violence throughout the state so that we can all continue doing what we do in Denim without fear of experiencing sexual violence. And whereas recognizing Sexual Assault Awareness Month and Denim Day can bring attention to the ongoing effort to put an end to sexual violence remain critically important. Now, therefore, be it resolved by the Senate of the 75th General Assembly of the State of Colorado, the House of Representatives concurring herein, that we, the members of the Colorado General Assembly, recognize April 2025 as Sexual Assault Awareness Month and designate April 30th, 2025 as Colorado Denim Day, a statewide event aligning with Denim Day events across the world. And we are proud to recognize the Colorado Coalition Against Sexual Assault and other organizations that continue to unite Colorado communities in support of ending sexual violence.
Madam Majority Leader.
Thank you, Madam Speaker. I am honored to support this resolution with Minority Leader Puglisi. We do this every year, and it's been something that's really special. Since 2013, the Colorado Coalition Against Sexual Assault has led the Denim Day campaign, where agencies and businesses and other groups pay a donation in exchange for wearing jeans or denim to work. Wearing jeans is a conversation starter and a visual sign of your support of survivors and CCASA's mission to end sexual violence, and Colorado Denim Day demonstrates the power of our communities coming together to support survivors and to take a stand against sexual violence. It's also a reminder that we are not alone. Our voice matters, and each and every one of us, every day, that are here with the work that we do makes a difference. And everyone that's standing next to us here and in front of us and those that are up in the gallery, thank you, because this work cannot be done without you and cannot be done without all of us focused on making sure that we break that code of silence when it comes to sexual assault, even domestic violence, right? That we continue to have the conversations. So thank all of you for your support. Thank all of you for your willingness and your contributions today.
Madam Minority Leader.
Thank you, Madam Speaker, and thank you to the Majority Leader. She asked me my very first year to be on this resolution with her, and I didn't know as much about it until I read it, and it has stuck with me throughout the years. And we continue to do this together as we raise awareness for not just sexual assault, but also domestic violence. It is never okay. Rape is never okay. Sexual violence is never okay. And by raising awareness today, but not just today, every day, that it's not okay, that we stand by survivors, that we are working in this state with more work to be done, but that we are working in this state to raise awareness, I think is really important. There are two statistics that I thought were really interesting and really hit home for me as a mom of an almost 14-year-old. 1 in 3 Colorado residents will experience sexual violence before the age of 25. Before the age of 25. And in Colorado, 42% of victims experience sexual assault before the age of 18, making youth a huge risk here in Colorado. We have a lot of work to do. And I hope that we don't just do this work today and stand up for survivors, but also do more to prevent victims in the future. So thank you for your awareness and for all of your support. As the majority leader said, we couldn't do this without you. Thank you.
Seeing no further discussion, the motion before us is the adoption of Senate Joint Resolution 18. Mr. Schiebel, please open the machine and members proceed to vote. Representative Soper, how do you vote?
Yes.
Representative Soper votes yes. Please close the machine. With 63 ayes, 0 no, and 2 excused, Senate Joint Resolution 18 is adopted. Co-sponsors. Representative Soper, co-sponsors. Please close the machine. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar to Thursday, April 3rd, 2025.
Seeing no objection, the balance of the calendar will be laid over until tomorrow, April 3rd. Members, it's announcements and introductions. Representative Weinberg.
Thank you, Madam Speaker. Fellow colleagues, I'd like to request a point of personal privilege.
So granted.
Thank you, Madam Speaker. Thank you, fellow colleagues. Please do me a favor, get relaxed so you can sit down. You don't have to stand. I'm just going to get through this. I don't know what you've been following with my city and the city of Loveland and what's transpired over the weekend. I'm not going to get into it. If you're interested, just let me know. But I wanted to make sure I came down here to represent my city in the best way possible. So I appreciate you, yes. I rise this morning for a point of personal privilege, not out of partisanship or personal gain, but out of deep conviction and respect for the office I hold and the community I represent. Public service is an honor. It is a calling rooted in humility, accountability, and a promise to put others before ourselves. When we take the oath of office, whether as a city council member, a county commissioner, or a state representative, we do more than sign up for meetings and legislation. We agree to be stewards of public trust. We agree to listen more than we speak, to serve more than we are served, and to lead not with ego, but with empathy. That trust is sacred, and when it is broken, when an elected official forgets who they work for and instead puts personal conflict, retaliation, or hostility above public service, then it becomes not just a local issue, but a reflection on all of us who wear the badge of leadership. In Loveland, the city I proudly call home, the people have spoken. In council chambers, outside of city halls, on sidewalks, and on front porches. Their voices have been clear. They are calling for accountability. They are calling for leadership grounded in respect, in professionalism, and in integrity. They are calling for a change in tone, in conduct, and in the way we treat each other in positions of power. I have heard those voices loudly, and I stand with them today. I stand with the residents who showed up to speak, not because they wanted to make headlines, but because they cared too deeply about their community to stay silent. I stand with every neighbor who believes that public office should never be used to intimidate, retaliate, or divide. And I ask you today to stand with my city too. What happens in one city echoes across our state. The example set by one councilor, one mayor, one representative can either build trust or tear it down. We do not have to agree on every issue to agree that leadership requires restraint. That service demands accountability. That titles do not excuse behavior. It is not enough to sit silently when the trust is broken. As elected officials, we must model the kind of conduct we expect from others. We must lead with character when the cameras are off, and we must remember that the office belongs to the people, not to us. Let this moment of reflection, let it be a reminder that the people are watching, not for perfection, but for decency, not for showmanship, but for steady hands and sincere hearts. To the people of Loveland, I hear you, I see you, and I will continue to stand with you, not only when it's easy, but especially when it gets hard. Because leadership is not about being right all the time, it's about doing what is right, even when it costs us something. To my colleagues, let us hold one another to the highest standard. Let us make it clear that the public office is not a place for personal crusades, but for public responsibility. My city deserves better than what is happening. Let me be clear that what is happening in my city is not the Loveland I know. And this ongoing embarrassment does not reflect the values of the city I'm proud to represent. Loveland is strong because it is built by its people, sustained by its people, and protected by those who never forget who they serve. A strong Loveland means strong accountability, and those of us entrusted with public office must rise to meet the people's expectations or step aside for those who will. Thank you for your time.
Thank you, Representative. Other announcements and introductions. I have one announcement. Representative Velasco will replace Representative Zokai on the House Committee on Judiciary today only. Representative Valdez.
Thank you, Madam Speaker. There will be no Energy and Environment Committee today. I'm sorry to report you won't have to see me in my Canadian tuxedo any longer.
Representative Lukens.
Thank you, Madam Speaker. The Education Committee will meet 10 minutes upon adjournment in room 107. We'll be hearing Senate Bill 178.
Representative Mabry.
Thank you, Madam Speaker. Judiciary Committee members, we're scheduled to meet at 1:30 in room 107. We have to wait for Education and Business to end, so I will be texting folks. Hopefully it'll be close to 1:30, but we'll start 10 minutes upon when the last upon adjournment committee gets out. We're going to hear House Bill 1264, House Bill 1304, and House Bill 1243.
Thank you. Representative Brown.
Thank you, Madam Speaker. Health and Human Services will also meet 10 minutes upon the adjournment of the morning committees. We will hear two bills today, 1287 and 1309. I will lay over 164 and 1146 to a later date. See you then.
Thank you. Representative Woodrow.
Thank you, Madam Speaker. Members, the House Business Affairs and Labor Committee will meet 10 minutes upon adjournment in room 112 to hear House Bill 1284, Senate Bill 31, and Senate Bill 36. We will not be hearing Senate Bill 144.
Thank you. Representative Hamrick.
Thank you, Madam Speaker, and thank you for all the representatives that came up and met with the kids from Overland High School. That was the high school I taught at for 32 years. I especially want to thank Representative Taggart for really going over the budget with them, which was wonderful, and Rep. Bacon for going over everything else. Overland High School, just for your information, is a school in Cherry Creek Schools. It has over 2,400 students. It's 82% minorities and 64% are economically disadvantaged. It's one of the most diverse high schools in the state of Colorado in Cherry Creek School District, where 140 languages are spoken. So I just want to thank you all for being such great hosts. Have a great day.
Assistant Majority Leader Bacon.
Thank you, members. Earlier today, you saw a bunch of sophisticated ladies in pink and green. They are here on behalf of my sorority, Alpha Kappa Alpha Sorority Incorporated, the first African-American founded sorority in the States in 1908. They are here today to bring the voices of the African-American community, particularly to the area of mental health and women's health. So if you see them in the hallways, please say hello.
Thank you. Madam Caucus Chairs. Rep. Lindsay, Rep. Joseph.
Thank you. Thank you, Madam Speaker. You know what we do when it's the two of us. You know what time it is. So we have Capitol Choir, and this one goes out to
special member. He's 90% of my name, doppelganger, Representative Lindstedt. I hear today he's 32. So let's sing him a happy birthday. Please come down.
Capitol
Let's
Choir.
get his cheeks flushed from embarrassment.
Ready? Yeah. Ready? 1, 2, 3. Happy birthday to you. Happy birthday to you. Happy birthday, dear Winston. Happy birthday to you. She doesn't want us.
Madam Majority Leader. Madam Majority Leader.
Thank you, Madam Speaker. I move the House stand in recess until later today.
It's a good thing they're a rowdy bunch today. The House will stand in recess until later today.